huge in cardiovascular care. So Chris managed heavy amount of IP there. Before that, he was at 3M for quite a while. That's where he and I worked together back when I was at 3M back at that time, and then some firms prior to that. Also a CEO of a startup company, mobile app company on that side. So kind of asked him to come in because Chris has a ton of experience on the large company side, startup side, wearable devices, kind of everything within there, in building through that. So Chris is going to give us a super valuable lecture that I wish I had in undergrad or earlier on. But basically, if you're building entrepreneurship, building a company, intellectual property strategy 101 stuff that is hugely helpful early on. Hopefully you guys got a chance to read through the assigned cases there, some relevance here, but really looking forward to it. So Chris, with that, I'll let you take it away.
All right, sounds good, Chad. And thanks so much for the opportunity to come in and speak with the class today. I'm very excited over the next hour to give you a crash course on IP, as Chad would call it. Since Chad and I have worked together, I've learned quite a bit more, all the way up to being a chief IP counsel now. And so my goal here is really to show you all the lookouts and the opportunities as you think about starting your companies, or even if you work for a large or a middle-sized company. You're going to be dealing with all kinds of competitive dynamics in whatever role that you take on. And it's very important to understand the issues that I'm going to talk about. And you won't remember it all, but my hope is you'll remember some of these key pieces when situations come up in any of those different scenarios. So I tried to break down today's discussion into 4 areas that I thought would fit nicely into 15-minute slots. My goal is really to sort of introduce each topic, talk about some of the best practices and lookouts, and then to the extent there's questions or comments around the case study, we can do some interactive Q&A if that works. Otherwise, we'll just keep going. But those 4 main areas are really around protecting your own innovations, preventing your business from getting disrupted by intellectual property from other third parties, making sure you're setting up and operating your company for success. And then a big piece that I deal with, and that I think all IP attorneys deal with, is dealing with third parties. No company does it all by themselves. And it's really important to understand where the lookouts for that as well. Obligatory disclaimer, because I'm an attorney, I got to mention that none of this is legal advice. These are my own views, and they don't represent the views of my employer either. But with that said, Chad gave a nice introduction for myself. Let's see if I can get my slides to advance here. Oh. So just very quickly, I think Chad gave a nice background. I'm trained as a computer scientist. That's my background. I worked a lot with electronics as well, but ultimately found myself going off to law school and becoming an IP attorney. I started my career at IBM. I worked at Ford Motor Company, both in technical capacities as a computer scientist. I then, after I went to law school, worked at a law firm where I did quite a bit of work for Google, actually, on their Android operating system. And so that was a very interesting and informative experience for me as an attorney. I then ended up going in-house and worked at 3M. So that's where Chad and I worked together. And we worked on technologies like powered air purifying respirators. It's a really interesting area in the industrial space where electronics and software are driving a lot of innovation, along with the physical science. I then took a little bit of a detour and I went over into medtech, and it's been a lot of fun. I spent the rest of my career in medtech. So I worked at Medtronic for about 6.5 years. A couple of the products you see on the screen, the top one that looks a bit like a digital popsicle stick is a Link insertable cardiac monitor. So you insert that over the chest just below the skin, and it detects different types of arrhythmias for patients who are dealing with different cardiac indications. And then that device on the bottom is a spinal cord stimulator. So it actually stimulates the spine to help mitigate and reduce pain for patients who've had traumatic accidents or other injuries where they need to mitigate the pain. I now work at MiniMed. So MiniMed was one of the businesses that was a part of Medtronic, part of the Medtronic ecosystem. We actually IPO'd back on March 1st of this year on 2026. So I've been heavily engaged in M&A activities. We're still doing a lot of post-separation type activities as well. So it's quite busy, but it's very IP rich. Some of what I'm doing will inform what we're going to talk about today. And then I did co-found a company called Item. It was a mobile app, had blockchain components, and it was in the community space as well. I did that with a classmate of mine from Johns Hopkins University, and frankly, it was a really, really good experience for me to really see the startup side of it and founding a company, and frankly, all the challenges that come with it, and also a lot of the fun and learning that comes with it as well. So all these experiences, they really inform what I'm going to talk about as an IP attorney. And I think it's really important to start off with what is intellectual property. And even before we get to the different types of intellectual property, it's really changed, I would say, over the past 25 to 30 years in terms of what intellectual property represents for a company. If you look at 1975, tangible assets were the primary asset in terms of market value. And by the end of 2025, intellectual property and intangible assets are constituting significantly more of the S&P's market cap. So intellectual property is driving the value of companies, whether it's your own startup or the company that you work for. And so it's really important to understand, what does IP do for you? And also, what are competitors going to use IP for as well in the competitive world? So there's different ways of talking about intellectual property, but there's really four big buckets that when I talk internally to my clients about IP, I really frame it up in this context. And I'll focus, in the interest of time, on patents and trade secrets, but we can talk about trade dress and copyrights briefly as well. So I start with patents because when people think of IP, they typically think of patents. And patents are a very important part of the arsenal when we think about intellectual property. Patents protect inventions. So I think all of you are familiar with inventions. These are new improvements in the state of the art. They have to be novel. They have to be non-obvious and fully described in a patent application. But they really cover those categories of technology that I show in the description there. So machines and articles of manufacture, if you have new compositions or processes, those are the types of things that you would seek patent protection for. We would pursue what's called a utility patent to cover those types of inventions. And then there's a separate category of patents called design patents. And design patents are really only covering ornamental designs. So if you recall that popsicle stick shaped insertable cardiac monitor, that design is that ornamental design, what it looks like, is actually covered by a design patent that I worked on. And so there are different ways of protecting both how something functions or its structure, as well as how it looks. And that's really in the form of ornamental designs. And so whether you're protecting your own products or you're thinking about potential risk from a third party, you have to be thinking about patents. They provide 20 years of protection for a utility patent, and that's from the earliest priority date. And if you get a granted patent, what does it allow you to do? It lets you exclude others from making, using, selling, or importing the invention that is claimed in your patent. And this becomes really relevant in the case study that was assigned to the class, along with the legal complaint that was filed, and we'll talk about that, obviously. But patents are a very powerful lever when trying to protect the value in your business, in particular the technical differentiation. And conversely, they can be a very powerful tool for competitors to slow you down or prevent you from selling your product as well. Equally important to patents are trade secrets and know-how. So more and more intellectual property that's being created is being protected by trade secrets and know-how. And this is particularly relevant in the tech space, where if you think a lot about AI, there are a lot of companies who will file some patent protection on AI for inventions where you could detect infringement, but there's a lot of innovation that's happening where it's compiled in source code or it's sitting on a server, and a third party could never actually reverse engineer how it works. And so rather than disclosing it in a patent, which has limited term of protection, you would actually just keep it trade secret, and your trade secret protection would be unlimited in its duration until you make it public or someone else can reverse engineer it. And we spend a lot of time, and I've spent a lot of time as an IP attorney, being very thoughtful about whether we protect our innovations with patents or we choose to keep something a trade secret. And so as you think about your companies and the employers you work for, it's very important to understand first of all, what is the technical differentiation? What makes us different? And then secondly, think about what forms of intellectual property would we actually use to protect it? And these are two of the primary levers, and we spend a lot of time, again, protecting our innovations using these categories of IP. Trademarks and trade dress, obviously, if you invest a lot of time building a reputation for your company, you want to protect that, right? You want someone to connect that word or that mark or that trade dress associated with your product with you so they can trust it, so they can easily identify it. And so we use trademarks and trademark protection to do that. When you think about the innovation that's happening in your company, you're going to be focused more on the top two categories, but you don't have a complete IP strategy unless you're really thinking about your brand and how that plays into your competitive advantage. And then finally, with respect to copyrights, depending on your business, this could be highly relevant or highly irrelevant, so I'll spend the least amount of time here. In the digital world, copyrights typically cover source code, but copyrights cannot cover functionality. So we typically rely on patents if you're developing a software product to protect the functionality. In the copyright space, you can use copyrights, obviously, to protect artistic content that you're creating. So all the creative that you have on a website or in your publications or your manuals or otherwise, you can use copyright, obviously, to protect that as well. So these are the four big buckets of intellectual property that anytime you're thinking about products or services, you're going to see intersections between these categories of intellectual property and whatever that thing is that you're developing. So what are some best practices? And these are things that I've worked on a lot with Chad. So I was reflecting almost 8 years ago now when Chad and I were working together, some of these different activities that we worked on. And I certainly work on these things at MiniMed today and with my team of attorneys as well. But it's really important to intentionally and aggressively develop your IP. So when you're busy with a lot of things that are happening within your business, IP can become an afterthought. So a lot of the time that I spend as a chief IP counsel is really building up a culture where people are incentivized and encouraged to develop their intellectual property. Because if you don't, you'll find a period in time where you actually need your IP, and because you haven't done it intentionally with a strategy, you'll find yourself wishing you had that lever. Okay, so if you're running your own business, or even if you're working with another business and you haven't heard about an IP strategy, it might be a question worth raising or beginning to think about. So when I speak about developing IP, I always think in terms of differentiation. That could be in terms of technology, it could be in terms of brand. But whenever a marketing team goes out and sells a product, there's typically technical differentiators that say, we are the only ones who can do this, or we do it better. It's really important that you have patent protection on those things as much as you possibly can, or trade secret protection, so that you have that moat or that wall around all the effort and resources you put into building out that technical differentiation. And that's similarly true for your brand. You need to police your brand, because as soon as you develop something valuable, others will look to fast follow on that, and they will attempt to profit off of all the work that you've had to put in to build up a trustworthy brand. So it's really about building out that intentional design. And I would say, if you're being strategic about it, a lot of innovation happens within your company, but there's a lot of innovation that's happening outside your company as well, in the same segment or the same market. I have absolutely run processes where we've gone out and bought really valuable IP from third parties, where maybe it was a dormant startup, or it was from a university where someone had done some cutting edge work and patented it. If you can get there first and get that IP, you can leapfrog your competition. And at a minimum, you can keep that IP out of the hands of your competition. So don't think just within your company, think about all the IP that's potentially available. And when you're thinking about invention disclosures, I'll try to sprinkle in references to AI, because AI is changing not only R&D and business, it's changing law as well. Be really thoughtful about putting your most sensitive confidential information or invention disclosures into certain AIs. And when I say certain AIs, what I mean is, if you're putting information into an AI that's giving you a service for free, they're probably training their models based on your inventions, right? Which can be problematic because one, it might be a public disclosure of an invention, which for patent reasons I won't get into, you don't want to do that. But two, you may be building up the corpus of publicly available information where you would prefer to keep that as a competitive advantage. So just be thoughtful. At MiniMed and other places, there are internal walled off models that are free to use, that are available to use. I'm sorry, you still have to pay obviously a service to set it up, but you can have more certainty that your information is remaining confidential. It's also really important to defend your IP. So if you're going to put all the effort into building up these walls and moats around your brand and your products, you need to actively monitor for infringement activities. It can be very detrimental if you spend all that money and effort building up your IP, and then someone else files trademark filings that are very close to or imitate your trademarks. It can be very problematic if someone's been infringing your patent for years and you're not aware of it or you're not reacting to it. And so be vigilant and have a plan for how you actively monitor that. I will say, as the Chief IP Counsel, the threats to your company will come from outside and they will come from within. So we have to be very thoughtful, and you do too, about, okay, if someone from the outside is trying to attack your network, I have a lot of intersections with our cybersecurity experts, making sure we don't have data loss or knowledge loss. But we also have employees who depart. They move on to new companies. And it's very important to have a very clear exit interview process and make sure you have appropriate systems and controls that if someone walks out with a trade secret, you can detect it and you can move quickly to get a temporary restraining order or other types of relief to prevent that from becoming public. Because typically once a trade secret becomes public, it's very hard to recharacterize it as a trade secret and give it that value again. So as you think about these things, as you develop your IP and you defend your IP, an enforcement action should also always start with a business objective. So sometimes the CEO will get exercised because a competitor is infringing a patent and maybe, we want to put a stop to that infringing activity, but what is the end game? Are we trying to prevent them entirely from operating in the market? Or do we simply want to get paid for their use and we're willing to take a royalty or some form of lost profits? So part of the task is developing your IP and monitoring it. And then once you consider enforcing it, obviously have that business objective in mind of what you want to accomplish. When it comes to leveraging IP landscaping, this is really important. This is something, Chad and I did together, and I do it with a lot of others as well. It's really important to understand what is the patent landscape in the segment you're working in. You should know who have the strongest patents. You should know where those white spaces are, where you can actually do brainstorming sessions and develop new IP. And so having that situational awareness around all of the intellectual property that's out there is going to be really important to innovate, protect your space. And when we talk about protecting our space, we don't mean just patenting the products or keeping trade secret the products we're developing today. We should be thinking 5 or 8 years ahead. Talk to your business development teams, some of your R&D teams who are looking further ahead, and make sure you're protecting not just the products you have, but all those alternatives and those future embodiments that may come down the road. And then finally, think about developing this culture of innovation. So as I said, when people are busy and there's timelines and there's capital constraints, IP can become an afterthought. So it's really important, have a training program where you train employees on how to generate IP. We do a lot of celebrations. We recognize IP creation. We give inventors financial compensation for going through the effort of filing an invention disclosure that gets filed. And when it grants as a patent, having those programs ensures that people are going to proactively generate the IP and make it available to the IP attorneys to protect. And on the risk mitigation side, you want to make sure that people are aware of, okay, this looks suspicious. Who do I go talk to, right? So you have to talk about the loss prevention side of it as well. And I think this all tailors really nicely into the case study. For those of you who had a chance to go through the case study, the competitive dynamics they're very fascinating to me because this is how it plays out in the real world all the time. You have sort of the incumbent, which is 3D Systems, and they've they've done a lot of work to build up their patent portfolio. And you've got the insurgent in the case of Formlabs, who has really identified a niche in the market, right? Where maybe these systems were large and they were complex and they were very expensive, and those products weren't able to serve a certain segment of the customer base. Formlabs saw that and they were able to exploit that, right? Entering into the market. But what 3D Systems did is they were very thoughtful in their IP strategy in terms of building up their patent portfolio. So if their segment was going to be attacked by an insurgent, they were able to respond to that with the intellectual property in their portfolio. And so with that, I'm going to pause if there's any questions. Chad, maybe open it up to the group here if there's any questions. Otherwise, I'll keep going.
Well, I do want to, I mean, I think there's a couple things to connect, some of the items you guys have had through the course. So, I mean, all of you guys are working on projects for these, various technical innovations, right, of some kind. And then all of those, and you guys have probably gotten a sense of it working on, there's years of research and money invested and a lot of work that goes into trying to figure those out. And like Chris talked about, what you don't want to do is spend all that time and money to be the one that figures out how to make it work and solve all those problems just for somebody else to say, oh, great, I'm going to do the same thing, right? So that's kind of a lot of that, defending that, because people will do that as soon as you're successful. The IP enforcement one with the business objective, I think there's a good analogy. Mike McCurry last week talked about when they were at e-ink and they had a potential patent infringer, and they made the business decision to acquire that company and buy them out instead of suing them and litigating it. And that's kind of exactly that tone. They're thinking about, hey, what's the end game, right, of what we want to try and do with all this and go in there. So those are big, and these are all things that, like, when we do it from the company side, we do things all day long and go through it. Chris, one of the things I kind of asked, and people ask me sometimes, it's always interesting when you think about for people to, because I think on the student side, there's not always a lot of exposure to the IP side. What are kind of basic tools that students can use to try and, take a look at what's out there and what those landscapes are?
Yeah, so I think, Google Patents obviously is a great site to go through. I wouldn't necessarily put your invention disclosures directly into Google Patents, but it's a very effective tool, frankly, to just go look at patents based on a keyword search. So if you are trying to develop a better sense of what the patent landscapes may look like, you can start by doing keyword searches and you'll get a long list of patents based on relevance. You can start to read through those and get a sense of, what are some of the more valuable assets in a particular segment. There are more specialized tools and services that are for subscription, but there's a tool called PatSnap. PatSnap sort of takes Google Patents and adds additional layers of analytics capabilities on top of that as well. So those are also opportunities, and there's a whole plethora of sophisticated tools to do the landscaping. And then the third lever that I use sometimes is I'll get a request from an R&D leader or a business development leader, and they'll say, I want to know everything about X, like a particular technology in a particular area. And the amount of work that's required to do that is actually quite significant. And so rather than having my in-house team try to pull that all together, you can use third-party consulting services or IP service providers. And what they will do is they'll take in the problem statement from you and say, I want to know everything about this type of analyte sensing for a diabetic patient. And they will come back with, here are the universities working on it, here are the top 10 strongest patents, here are the startups that are working on it. Those reports cost money, obviously. It's not hundreds of thousands, but it's in the tens of thousands. But it can really speed you up. So if you're thinking about innovating in a particular space and you feel like the task is very daunting to go in and obviously use the tools I've been describing, there are services you can use that will build out a report for you and just hand it to you. And then you can use that as your starting point for analyzing a space.
Yeah, perfect. Thanks, Chris.
One thing I would mention is I grew up at Motorola. We had a patent scrub process built into our product development teams. So before proceeding too deeply into any new product, we would always try to understand the IP that was involved, what IP we might be infringing, are we leveraging the white space correctly, and what we should be filing and not filing. And I think that helped us keep everyone on the same page. We would do that periodically up until the point of launching the product.
Yeah, very well said. And I think one of the key points in what was just said is it's an iterative process, right? You go through different phases or milestones within your program. You're always going back to say, have we scrubbed and have we captured all the intellectual property that we've most recently developed? And again, we're sort of limited on time, but it's really important to know that at least in the patent side of things, priority dates, in other words, the date you first file your patent matters, because that defines what exists as prior art to your invention and what does not. So getting to the patent office quickly after you develop your invention is important. And again, doing that refresh all the way through the product development process is just really critical. Okay, so in summary, as we think about the case study, you have 3D Systems, right, who is the incumbent player in the market. There are others, obviously, in the case study, but they've obviously made big investments in the technology. They're trying to serve a certain type of customer, and they built up their portfolio of patent protection, right? So they're thinking about competition. They're probably monitoring for insurgents like a Formlabs, for example, and they're probably already preparing by looking at things they can publicly discern of the Formlabs product in comparison to their patent claims and saying, do we have claims that would read on their products such that they would infringe? And that would give us leverage to have a conversation with them or use the legal system to achieve a business objective. The flip side, which is the Formlabs side, is, look, IP suits are very, very disruptive, and they can be very consequential. So attorneys are very expensive, but even beyond the cost of the legal fees to litigate and have a fair hearing in court, you have to worry a lot about distractions and disruptions. So if you're already running lean and you have to apply a lot of capital to continue moving your R&D forward and your business plans, when you get an IP suit, all those people in your company, they're going to be distracted because they're going to be deposed. They're going to have to gather documents. They're going to have to support the IP attorneys, and it's going to impact your strategy and your timelines because you might have to redesign your product due to IP infringement risk. If you're infringing a patent, you may have to design around the claims. If your product is found to have incorporated misappropriated trade secrets, you may have to rebuild your product in a clean team, right? You may have to do things that convince a judge that you're not still using the misappropriated IP. And so it's very, very disruptive. And there's examples where, startups or small companies basically stalled out or went out of existence because of IP suits. And so I listed the Groove Shark example, essentially went out of business due to copyright infringement claims. And then the Amaranth versus Ordix, the startup went out of business due to some patent infringement issues as well. And so this is not theoretical. This kind of thing happens, and the incumbent company is going to do everything they can to keep other competitors out, right? Now, they need to do that fairly and in compliance with the antitrust laws, but they're free to assert their IP to protect their space. And so it's really important to proactively manage the IP risks, right? And a lot of IP risk, it can be identified early and managed. So if you're doing this thoughtfully and you're doing it proactively, you can be aware of a competitor's patents and you can be designing around their claims. You can go out and seek IP licenses. Sometimes you'll just go out and say, look, we're coming to the market. We need to negotiate a license, or maybe it's a university who's not going to make the product themselves, but you still need to pay fair value for access to that IP. And so it's really around being proactive and being preventative here, because when you get subject to due diligence, if you're trying to raise capital, if you're trying to sell your company, or if you work for a big company and you're going to launch a product, leaders are going to demand that you have checked the box on managing your IP risk. You can't skate through it, in part because a lot of companies have been disrupted by IP risks, right? So it's just really important to get the IP risk assessments right. There's a few ways to do this. So the main activity that you may hear about, whether it's your own company or you're working for a big company, is performing freedom to operate. So freedom to operate analysis means you clearly understand what your product design is, and we do this on the brand side as well, but you understand how your product works extremely well. And you also understand what that third-party IP landscape looks like. So in the case of 3D Systems and Formlabs, it would be in Formlabs' best interest to look at the patent landscape and understand if 3D Systems or other competitors have patents, right? Because if they have patents, you have to deal with that. You can't continue to develop your product and just launch into risk. You'll be enjoined, you'll be accused of willful infringement, and those things happened. Not the injunction part, but the rest of the legal risk happened for Formlabs when they did this. And that's not to say they weren't doing their diligence, because they did make comments that they saw patent cliffs, or what that means is patents were expiring. And so they thought they had an opening to enter the market and not experience an IP infringement suit. They got it anyways because 3D Systems was probably watching and trying to get as many patents on that product as possible. But you have a responsibility to do this freedom to operate analysis. It should be done in conjunction with an IP attorney so you can maintain privilege over those opinions as around infringement risk. But it's an essential activity. And again, investors or any business leader is going to ask, have we cleared the product against third-party intellectual property risks? I'm a big believer that that offense is a great defense. So in addition to making sure your products don't infringe third parties, you should try to establish competitive leverage against all the others in the major players, I should say, in your segment, right? So if Formlabs was thinking about this competitive dynamic and the intellectual property situation, they might say, well, we're going to come in second to market, but could we acquire some patents that maybe we could assert? Are there other things we could do to have some leverage to counterbalance the leverage that 3D Systems has as the incumbent? So think carefully around how you're going to develop that offensive leverage, but that becomes a great defense because it's a check on your competition, and it may cause them to say, well, it's not worth the fight here. Typically the incumbent too, from a competitive dynamics perspective, they're going to have more revenue at risk, right? So anytime they think about asserting their patent against a smaller company, if the smaller company has any IP leverage whatsoever, the bigger company has more revenue at risk and needs to think very carefully around whether that fight is actually going to be worth it and whether that fight's going to be accretive to their share price at the end of the day after you pay the lawyers and you wrap up the fight. So again, maintain that leverage, but also be thoughtful in your freedom to operate. Freedom to operate, maybe moving down to the bottom left corner, it's an ongoing process. So I think everyone understands that when you file for a patent, you're not granted the patent initially. You file what's called a patent application, and then it's examined at the patent office until it meets the statutory requirements for a patent. So it has to be novel, it has to be non-obvious and fully described in the patent application. New patents continue to grant every week. And so even if you thought you had clearance a year ago, you need to refresh that, right? Because these competitors are going to be looking at your product and trying to get claim coverage in patents on your product. And there are third-party intel services. Some of what I referenced earlier, Chad, is what I'm referring to here that can actually do the monitoring for you so that you're getting reports or your IP attorney is getting reports. And as new things come up, particularly from strategic competitors, you can look at that quickly and address the level of risk. And then finally, manage your third-party IP relationships. Again, nobody operates a business without having to interact with suppliers, with development partners and others. You really need to plan when you set up a third-party relationship for those off-ramps. So everyone thinks about doing a deal with a partner, whether it's a supplier, development firm, or otherwise. And everyone thinks it's going to work out perfectly, and it rarely does. So you need to be talking with your attorney around what are my off-ramps? Where can I get out of this agreement if I have to? We obviously want to build trust in any sort of contractual relationship, but if your only exit is a termination date 20 years from now, you're in big trouble. You're stuck with that person for a long time or that party. So manage that third-party relationship aspect carefully. And then I'll talk later about IP contamination when we get into third-party relationships. So the competitive dynamics, I would say, in 3D systems and form labs is not uncommon, right? You typically have, 2 to 3 big strategic competitors who have, the bulk of the market, and you have a smaller company who sees a niche in the market where there's an opening, where there's an underserved customer base. In this case, it's users or customers who are looking for a cheaper, smaller version of a 3D printer for additive manufacturing, right? And so Form Labs went after that, right? And I think both sides, 3D Systems needs to think about how they preserve their lead in the market, and Form Labs needs to think carefully on how do I enter using the capital I have without encountering a direct IP disruption, right? And so it's a very fascinating area. I love obviously practicing IP law. I'm very passionate about it, but you'll see this dynamic in pretty much every segment that's out there. So with that, I'll pause again to see if there's any questions or comments from Chad or others as well.
There's a question over there. Go ahead.
So is it important to keep a legal team as a startup, or maybe just an advising attorney at the beginning of your journey?
Yeah, it's a great question. I think the way I would see it play out most often is that when you're a startup, you don't have the capital to have a full-time general counsel, which is typically the first lawyer that the company hires and is the top lawyer in the company. So you'll start by working with outside counsel. You'll work with a law firm, and a law firm will typically be able to provide a startup with all kinds of advice and counseling, whether it's intellectual property or corporate issues as well. And so I would typically recommend you identify a trusted and respected outside counsel. And then as your company grows, you would then hire on a general counsel. They would manage all the legal issues that you have, including IP, and you would continue to access those IP services through the law firm. And then once you're big enough, you would hire on your first IP attorney and then build a team from there as well. So I would not recommend hiring an IP attorney in-house initially. I would leverage your outside counsel partners so you're only paying when you need the services, but they do need to be doing these kind of things for you as well. So obviously sitting down with them and saying, hey, I think we need to do a freedom to operate exercise on my products so that I know I'm not going to be disrupted by competitors X, Y, and Z. They will absolutely help you out with that. Obviously, you'll want to ask for a budget, a timeline, who's going to be working on your project, but they'll put together that team and they'll do it in a way that you have predictability around the costs. Does that answer your question?
Yes, and how often would you need to be aware of this sort of thing?
Yeah, so it goes a little bit to this idea that, new intellectual property is coming into existence all the time. So it's, depending on the segment you're in the industry, you will sort of settle on a plan with your IP counsel on how frequently you want to refresh your FTO, right? You might refresh your FTO each time your product changes. You might also, because you have new features, right? And that may cause you to infringe new patents. So product changes are a good time to refresh FTO. You also just want to do it on an interval, and that interval is segment specific. So some industries move really slowly, others move very quickly, and in some areas it's IP heavy and others it's lighter, but you might refresh it every year or every 6 months or some other cadence, but it does have to be refreshed. Otherwise, you'll eventually find yourself running into an IP risk that came up after you did the initial FTO.
Thank you.
Great questions.
Do you recommend having a lawyer perhaps as an advisor on your advisory?
Yeah, I think it can be really useful. I think sometimes lawyers get a bad rap for being too risk averse or only seeing the risk side of the equation. But if you can really find a trusted legal partner who's thinking strategically about advancing your business, they can help identify pitfalls that other non-lawyers could not, right? And so I think to have that complete perspective on one, how to manage IP risk, but two, how to capitalize on the IP opportunities can be really powerful. So assuming you can get someone in that you trust and is highly competent, I think it can be a really strong addition.
Thank you.
Hey, Chris, for this stuff, the third-party intel, maybe even evaluating claim scope and so on. AI tools are becoming so powerful. When do you think they're relevant, or maybe they're already, useful in these and other related contexts?
Yeah, it's a great question. I think they're already relevant. I think I won't endorse any particular product, but I mentioned PatSnap. There's a tool called IP Rally. It's really good at finding prior art. So if you're wondering if your invention is patentable or not, or if there's patents granted out there that are really similar to technology that you have described, those tools can really cut down on costs, and they can be good enough, right? Like at the end of the day, there's hundreds of thousands, there's millions of patents. Somehow you have to be able to funnel down. And even if you funnel down that initial set of patents to 100, that's a much more tractable problem for your IP attorney to get their arms around as well. So if you're not using AI and your attorneys are not using AI at some capacity, you're probably at a competitive disadvantage because you're doing things that are slower and more costly. So we always look to say, okay, does it improve our quality? Does it improve our efficiency from a cost and timing perspective? And if the tools will tick the boxes on those things and obviously respect our privacy and confidentiality of our information, they're worth trying out and using. And you're seeing these tools come in at every sort of IP activity there is, whether it's patent drafting, prior art searching, freedom to operate analysis. There's even a tool out there now that when an inventor puts their invention into the tool, it will sort of go through this quality check and provide sort of output that can then more efficiently get you back to the inventor saying, you need to fill this out more, or this is good quality, and we'll move it on to file it. So it's a great question, and I think everyone needs to be looking at those tools.
Another question over here.
Yeah, I had a question about how do you have any strategies for identifying whether the counsel that you go with is too risk averse, whether slowing down some of that innovation progress, you have to take some risk at some point. What are your takes?
Yeah, that's a really good question. So I spend a lot of time as the chief IP counsel talking about taking compensated risk. Okay, so I distinguish compensated risk with my internal clients, which includes the CEO of the company, from reckless risk, right? So, and then on the other side, there's taking zero risk. And what I always tell people is we need to take risk that ensures we remain competitive, right? If we take reckless risk, we run into what 3D Systems and Formlabs did, right? That's where you kind of just ran into a wall of patents and you ended up with a big problem. On the other side, if you take zero risk, you will develop an uncompetitive product, right? Because you will design around patents that maybe never should have been granted or that you don't infringe, but it's a close call. And so you end up with an uncompetitive product, right? It just doesn't have the features that a customer is really going to look for. And so I want to answer your question directly, which is, how do you know if you're taking enough risk or not? And I think there's different ways to come at it. Like, obviously, you could get a second opinion from another law firm if you think that your current firm is being too conservative. But a lot of what clients ask me is, Chris, what is the next aggressive option? Like, if you're telling me, we're going to infringe this patent if we do X, okay, what's one step down where it's going to avoid the infringement risk, but we can still get the product out, right? So challenge your counsel to tell you what is the next conservative option down, or what's the next risk that I can take, or even say what's a big leap in risk that I would take, right? I think if you structure the question that way, it will force your counsel to think harder about, okay, well, maybe we could get a license, or maybe this patent is invalid. Like, let's just go and find the prior art, because everyone seems to think this was already out there in the prior art before the patent was ever filed. And so I would challenge your attorney that way. It is tricky though, right? Because you may be getting lots of conservative advice and it's slowing you down. I think then you do need to get a second opinion from another attorney. And a lot of them will do that for free or lower cost because frankly, they want to bring you on as a client, right? And then you get two perspectives and you can either continue with your first attorney or you have your second. And I will tell you, I work with many lawyers outside counsel, and different lawyers have different levels of risk calibration. I go to different tools for different jobs. If I really have to think about taking a lot of risk, there may be attorneys who are better at helping me to manage that than others. So I do think the second opinions are good, as well as challenging your attorney to say, what is that next aggressive thing we could do, given the advice you've given me? Yeah, that's a great question. It's one of the toughest questions because we struggle, and I think all IP attorneys in-house and externally struggle with taking the right amount of risk that doesn't get the client into trouble, but also lets the client develop the product they need to be competitive.
I will mention that Northwestern Law School has something called the Bloom Legal Clinic, which is a low-cost, student-focused legal clinic for things like business establishment, IP, labor law. Yeah, I think they might even do immigration. So I think there are some low-cost alternatives for students in Northwestern that might be worth considering.
Yeah, that's great. Definitely take advantage of that. It's a great entry point, right? To just starting to get legal advice. And obviously all people who are developing a startup are going to have lots of legal questions. So take advantage of those resources if you have access to them.
Another one.
I hope you can hear me from the back, but I have a question. First of all, thank you for the talk. For student founders, especially, how do you balance sharing your idea with feedback while still protecting it? And also, if the technology is still evolving, how early should we play with it?
Yeah, good question, Chad. I think I heard it, but could you repeat the 2 points, the 2 questions?
Yeah, so I think it was for student founders, how should you balance kind of discussing your ideas with protecting your IP, and how early should you file patents there?
Yeah.
Oh, yeah, I'll start with the first. I'm sorry, I'll start with the second question first. If you have an invention that's patentable, I would highly encourage you to just get a provisional patent application on file. So it's essentially a placeholder. It's filed with the USPTO and it documents your invention. You can include patent claims at the end and you get a year to convert that into a utility application. Filing fees are much cheaper, but the most important thing you get is you get the set of inventors who came up with the idea documented at the USPTO. So there's an objective stake in the ground as to who invented what. And then if you need to go off and talk to a company, you've at least got that amount of protection. Even if you're under NDA, it's sad to say, but there's bad actors who will hear out your ideas and they'll go off and file the next day in violation of the NDA. And then you've got to fight uphill with competent counsel, and you should. But having that patent filed demonstrates that you have priority before they filed theirs. And that's always going to keep their invention as, coming after yours in time. So I think what we did is we did file a patent application early. It made it a lot easier to talk to investors because investors typically don't sign NDAs. They're just, they want to hear from you, obviously, and you need to talk freely about your ideas. And so if you've got a patent application filed, at least, you get more latitude around that. If you have more of a know-how based business where your technical differentiation or the value is really in the know-how, then you have to be a lot more thoughtful about how you're talking about your IP so you don't inadvertently disclose your trade secret and give it to someone else, right? Because that essentially takes your competitive advantage away. So a lot of times you can go about it by talking about the inputs and the outputs of your trade secret, right? So if you have certain performance characteristics that no one else can replicate because your technology is just better, whether that's software or it's a manufacturing process or otherwise, you shouldn't give away those details, right? You should be able to say, I can demonstrate for you that we can get to this level, but I'm not going to tell you how we're actually doing it, right? Obviously, if you put the trade secret in a patent application, it's public, it loses its trade secret status, and you get your 20-year term if you can even protect it with granted claims. So again, you've got to talk to your IP lawyer about this, depending on what kind of business you have. But those are the different ways I'd come at it. So I think I answered both your questions, but I would file early on the patent side. And then secondly, was it how you talk with others about it?
Yeah.
Okay. Did I answer both your questions? I can elaborate further if I.
Thank you so much.
Okay.
I had a question. If you're a small like startup bootstrap company and you have some IP that you invested in, and you see that there's some possible infringement from another company, maybe it's a large company. I guess in kind of retrospect, let's say like it's 3M or some big company, and
Sure.
And you don't want to really spend a lot of money. You don't have a big bank account. This big behemoth company has a lot of money, a lot of interest in. Like, what would you say would be a good strategy, if any, that you could, like pursue some type of get their attention, not be too aggressive, and maybe have some success based on what you've seen in the past, like for instance, if you didn't want to go to an IP attorney, you want to write a really nice letter, you send it to a certain person. Like, from your side of things, is there any way that it would get your attention and maybe would kind of progress in a right direction? And like, what would you do and what would you definitely not do?
Yeah, great question. I'll talk about strategy and I'll talk about funding as well. So I think most companies, not all, but I think most companies really do try to respect the valid intellectual property of the rest of the world, right? So if you're a small inventor, but you've come up with something that's valuable in the space and our technology requires access to it, I think most companies are open to a licensing discussion, right? Or acquire the IP. So I think most companies try to operate that way because the optics look really bad if you essentially have a David versus Goliath match in court where there's a solo inventor who did come up with something and essentially the company is ripping them off, right? So I think companies do try to take those sort of letters that you're talking about. I think they try to take those seriously. Now, how to actually approach it, I wouldn't necessarily suggest waiving a patent in front of a big company like 3M unless you've at least preliminarily talked with a firm, right? Because what they're going to do is help you set up the right way to approach it. A lot of conversations that are productive start with, hey, we see you developing product in this space. Long time ago, we developed some IP and we think it might actually help you with your business plans. It might help you accelerate your product or add in a feature that customers really want. So instead of saying you infringe our patent, we'll see you in court, you say, I can help you by giving you a license to this IP. I just expect fair compensation. And so framing up the letter the right way and then having a plan for the next steps is really important as well, because depending on how the letter is written, if a big company perceives that as a threat, they can actually move first. So they can file what's called a declaratory judgment, which lets them move first and say, well, we think the patent's invalid and we don't think we infringe and we're picking our favorite venue to go have that litigation, right? So you have to phrase it more constructively than adversarially. But once you get down the licensing pipeline, it's more a conversation around, do these claims actually cover the technology of the company? How much value does it add? If it's a really narrow patent claim and you sort of technically infringe or not, your royalty rate may be lower. It also depends on the industry, and certain industries have really high royalty rates and others have low. So I do think having experienced competent IP counsel is important for some of that. Make the investment, set aside 10 grand or whatever it's going to be, and get good advice. Now, if you think that a big company is really ripping you off and you don't have the capital, you don't have the revenue to actually fund your litigation, there's a new category of investor out there called a litigation funder. And what the litigation funder does is they bring capital to the table in exchange for some part of the success if the patent prevails, right? If you prevail in the patent infringement suit. This is a whole cottage industry that's out there now. And if you're lacking in capital when you talk to your law firm, you can have conversations around litigation funding, right? And get capital behind you so you can fund a patent litigation. I've been around patent litigations that have lasted 8 years with 9-digit results that went one way and then went the other way as well. And so well-resourced companies can go the distance. And so you want to make sure you're funded to go the distance as well. So litigation funders are sort of the, sort of leading way to do that if you have a valid claim. Yeah.
Thanks.
There's also contingent fee law firms that will litigate, right?
Yeah.
They will litigate as well. Yeah. And you'll want to talk to multiple law firms and see what structure works best for you. But yeah, contingency is also an option. It's a very good point.
You've talked about what to protect, but not necessarily yet, to my knowledge, where to protect. So there's a whole issue of global IP strategy. Are you getting to that, or is that something that's like beyond the 1 hour time?
Yeah, no, I can speak to it briefly because we're gonna pivot to 2 other topics that are not that, but it's a good question, right? So what does a patent right give you? It gives you the right to exclude others from engaging in that, from making, using, or selling that invention, right? So typically the countries you think about filing in are countries where you're selling or your competition is selling, right? So you want to be able to exclude competitors from taking share from you. If you're both selling in the United States, obviously having a patent in the United States is important to try to block them or force them to design around. We also think a lot about where products are manufactured. So supply chains are global now. So you might file patent protection in China or in other manufacturing hubs. So you have patent protection there, block the competitor from actually making the product there. And then importation is another right that gets overlooked sometimes, but there are certain countries in the world where goods and services flow more freely. So the Netherlands, you'll often see as a port of entry for a lot of products. You might see more filing in the Netherlands. There are similar countries in the APAC region as well. And so, yeah, you need to sit down with your marketing team and say, where are the competitive dynamics, right? Where do we need to block our competitors? Where are we generating our revenue? And that's where you'll pick countries that you'll file in, because you can't file in every country unless you're Qualcomm, because they have video coding technology in every country in the world. Then you'll file much more broadly. But in general, you got to do that kind of work.
Got it. Okay. Thank you.
Great. In the interest of time, I'll keep going, but obviously if questions come up, please come back. So these are a few practice pointers, and I'm looking at time. I want to be thoughtful, obviously, on time as well. So I'll go through some of this a little more quickly. You do want to set your company up for success and operate it for success as well. So I tried to highlight a few examples of where early founding issues can have some pretty significant consequences. With Snapchat, there was one founder who was ousted, ultimately got paid out for his contributions. And with the Bratz dolls case, the founder there was actually working on Bratz while working at Mattel at the same time. And so company time, company resources being used to develop a competing brand, that can be a big issue, right? So the main takeaway here is engage with a competent lawyer early. There are some really good law firms, particularly in the Bay Area, who will actually do a lot of legal work for free at the beginning, and they'll sort of backload the fees. So they obviously want you to come into their firm, support, you and your legal needs. And then as you become more successful, they start charging you once you have more revenue or you become a more mature company. So again, get competent counsel early. And again, they may defer fees. And then choose your co-founders carefully, right? So like if you're thinking about starting a business and you've got a really great idea, and there's lots of resources online about, the types of attributes or things to think about when picking a founder, you've really got to make sure that you and that person are both complementary. You bring different skills to the table that fit together well, but that you share similar values about, how much effort you're going to put into your startup. What are you going to do when a crisis hits? And generally, if you're getting asked questions around the history of your company to raise capital, they're going to say, how long have you known this person? Where'd you meet them? Like, why do you have the right dynamic and the complementary skill sets? So that's a really important piece when you're getting off the ground with a startup. Okay. I'm sorry, was there a question?
No, it's just me.
Okay. Might have been some feedback. Okay. So company formation, obviously very important. If you're coming up with an idea early on, you're working with a few others on an idea, or you're bringing an idea to others, document those discussions, the concepts and designs between the co-founders and inventors. In the Snapchat case, there was a patent application that was filed. That was good objective evidence of who had actually contributed to developing the most critical features, but document that all at the beginning so that if there ever is a dispute, it's easy to look at objective records that have timestamps or other things. If there's a lot of talking into the ether and not a lot of documentation, it gets much harder to resolve those kind of disputes as well. Most employee agreements will prohibit the use of company time or resources. If you're going to develop something, it's got to go be owned by the company. So have that clear understanding. You can talk to your own personal attorney about this, or read your employee agreement. But if you're going to work in a similar space in particular, you can't be using company time and resources to develop the same technology unless you have a contractual understanding with them. Otherwise, they're going to say, look, you actually have to assign that IP over to the company. And then your lawyer will do this for you, but make sure that all the IP is assigned to the company at incorporation. You don't want loose threads where there was some source code or a patent application that never actually got assigned into the company. That just becomes a headache the more successful the company becomes. And again, investors or business leaders are going to demand you get that cleaned up. Employee agreements and controls, anyone who comes into your company to do work on it, you got to have them signing an agreement. I've seen this more and more where it's like, well, we had a consulting arrangement. It was sort of informal, but they saw our know-how. And by the way, they brought some competitor know-how into the company. Now you've got an IP contamination issue. It just gets really messy. And because it's so fact intensive, particularly on the know-how side, it's very hard to get investors confident in you again if you've essentially brought in all this confidential information to your company. So have those agreements in place. They also cover where does IP that gets generated get assigned, right? The company should own that. And then I spoke to it earlier, but have those loss control, loss prevention mechanisms in place so that you don't have your trade secrets and know-how walking out of the company. I want to touch briefly on attorney-client privilege, because this does come up, and I do IP bootcamp trainings. If you think about the United States and having a legal dispute, the attorney-client privilege is designed to shield those communications that you have with your lawyer, but only those that relate to providing or receiving legal advice. So, if Chad asked me where the light switch was on the 13th floor at 3M, that wouldn't be privileged unless there was some sort of legal issue with it. But if he asked me, is this patentable or not, that is covered by privilege, right? And so you shouldn't be sort of lulled into thinking that attorney-client privilege protects literally everything you say to your lawyer. It is designed to ensure that you have full and frank discussions on legal issues. And so obviously, if you're talking about legal issues, that's covered by privilege. If there's ever litigation and there's a discovery request or a subpoena, you don't have to turn that over. A few things besides business information that's not covered. Doesn't protect fraud or crime. So if you're trying to use the attorney-client privilege to engage in fraud or other crimes, it's not going to be privileged. The judge is going to see it, and it's going to be in front of the jury and others as well. And you can waive it. So if I send Chad a privileged communication that says, Chad, it's high risk to implement this feature because the 789 patent is going to pose a risk to us, and Chad forwards that on to 13 other people in the company and doesn't copy me, there's an argument we've lost privilege because now it's uncontrolled. It's not treated as confidential between Chad and me on that legal issue. So when you get legal advice from your lawyers, don't just forward it around, right? And don't just share it with others. Otherwise, you could lose the privilege, and then you waive the privilege on the entire issue. So all the documents have to come out. And that gets to my last point. Be very thoughtful how you write. So this is just whatever you do, regardless of IP. Be very thoughtful about what you put in writing. If you say, look, our product is killing people, I'm giving you a really extreme example, or this feature is harming a lot of people. Think about how that's going to be characterized in front of a jury someday, even if your opinion was uninformed or incomplete, right? Or, if Chad wrote me an email and said, Chris, we have to do what's in the 789 patent. Well, Chad could be reading the summary of that patent, which isn't the enforceable rights, the claims are. But the first thing that the other side's going to do is pull Chad's email up, put it on a projector in front of the jury and say, see, they ripped us off. They said we needed to use this patent, even though the claims are never going to be infringed because they're so narrow. So just pause if you're writing on a sensitive topic. There's a few areas, IP, product liability, antitrust in particular. You just got to be really careful how you're writing. And if you're not sure, just pick up the phone. I talk to people all the time. It's really effective. It's a lot more efficient sometimes as well. So be thoughtful how you write. And then finally, I'll skip over this so we can get to the last unit. Have an IP strategy, even if it's a very lean IP strategy and it's one slide. It's like, look, we intentionally protect our IP by doing these things. We are doing freedom to operate to make sure that we're not infringing third-party IP. And we are managing the way employees come in and out of the company, right? It could be as simple as that, right? But if someone looks at you and is thinking about investing in your company and they say, well, what's your IP strategy? And you just stare at them like a deer in the headlights, it's going to be a hard conversation, right? Now, they might say, well, look, we love your idea, but I'm going to connect you with an IP lawyer I trust. You're fine, right? But it's always better to say, I'm at least checking the big boxes on an IP strategy. Okay, I'll pause there, and then I've just got my last section of the slides here before we wrap.
In my mind, this one slide is a great summary of what legal considerations all startups and entrepreneurs need to consider. At least it's a good place to start.
It's a great starting point. Your IP attorney or your business attorney, they'll help you go deeper. They'll tailor your strategy to your business. But you got to be thinking about these issues because they'll catch you off guard, and you may have done everything else right in terms of solving a critical problem, and you get tripped up on a legal issue, and it's really hard on the company at that point. Okay, I'll jump into the last part of the deck here. All right, so I call this the sharing the trail section. I spend a good chunk of my time as the Chief IP Counsel thinking about conflicts, thinking about M&A activity and partnerships, right? These are interactions we're having with third parties. So not things that are happening within the building, which is a lot of what the first 3 modules we're talking about. It's really more about how do we advance our business, right? And leverage comparative advantage from other companies where we can't do it all ourselves. And I just put a few representative statistics up here. There's many others, but whether you're in a startup or if you're in a mature company, you're going to have third-party interactions. You're going to interact with third parties. You need to do that thoughtfully in planning. So you don't just set up a meeting with a potential strategic partner and start telling them about all the confidential things within your company, right? You don't have an NDA in place yet. You're making all that information public, and they're happy to take it until you get a legal document in place. So you've got to think about being at arm's length. But you've also got to consider getting the deal done as well. And so I'll get into some of the instruments you can use to do that. This is the crash course. Your lawyer will take you through the details whenever you do something like this. Okay, so non-disclosure agreements. I think everyone is pretty familiar with a non-disclosure agreement, but the basic idea is, look, one or both parties, they have something to say, and they don't want the rest of the world to know about it. And so you sign a non-disclosure agreement, and it basically says, the receiving party, they can't disclose that information to other third parties. That means just anyone else other than the parties listed on the NDA document. They can be mutual, where both sides have to keep the information confidential, or they can be one way, where, look, we MiniMed will share a confidential information with you. You have to keep it confidential. But anything you tell me, I can put in the New York Times. I can post it anywhere I want. And you got to be very careful about what kind of NDA you're signing. So get good legal counsel. They'll step you through things like use restrictions. So almost all NDAs specify a purpose, right? We might be talking to another company about, hey, we could partner together because you have great technology here and we're a leading company in this space. And the only way, or I'm sorry, the only use that I am permitted to use your confidential information for is to engage in a transaction with you. So you're going to show me your confidential information or technology for the purpose of engaging in a transaction, like an investment or a partnership. What you're not allowed to do is take that technical confidential information from the other party and you build your own competitive product and then cut them loose. You will get sued for trade secret misappropriation, for breach of contract, and a long list of other claims. So don't think you can sign an NDA, sort of raid the other company, and then walk away. You will get sued and it will be very, very painful. So don't do that. The last piece is, and I've heard this over and over again throughout my career, people will say, well, we're going to go into a whiteboarding session now under NDA. So we got an agreement in place and we're just going to we're going to solve these technical problems. And anytime you solve technical problems, you're creating technical solutions. And if you go all the way back to the first module, technical solutions are patentable, right? And so if you are doing this under an NDA, almost all NDAs have no IP terms in them. So if I go into a room with a partner who then becomes a competitor and we jointly create a bunch of new patentable inventions, we jointly own those inventions. And now you've got a problem, and you've got a bigger problem if you made a big investment in your company, but you co-created a bunch of joint IP in a whiteboarding session. Now that other party is a co-owner in that IP and they can license it to your competitor. So don't use an NDA to manage IP creation. That's why you have what's called a development agreement. So it's the next box down. A development agreement is more like a supercharged NDA. So it's got all the confidentiality provisions in it, but it goes further. So it has an explicit framework for IP ownership. You want to include in their resourcing commitments. So if you need that other party to perform and deliver something to you, you better specify resourcing and what happens if you don't reach a milestone. Because I have seen documents where there are commitments made, but there are things lacking like resourcing. And the other side never shows up. They just say, look, we got other priorities. We're sorry about that. And that component or that service you need, it never arrives. And you can't complete what you need to do and you run into big problems. You'll cover commercialization in some of those agreements. That can get pushed further down the road. But if you're in any way going to create new technology with a third party, i.e. not your own company, you need to think about having that development agreement in place. Otherwise, you're going to be stuck in that NDA scenario I talked about where you're going to think you're covered by your NDA and that, hey, I own this, or we're going to figure it out. And you're just going to be stuck with a co-owner of the IP you created. Okay. IP contamination. So this is a big one. There are litigations out there that you can go and look up where a company is operating and they're operating in a particular segment. Okay. They hire employees from a competitor. They hire consultants who consulted for a competitor. They come over and work at the company in question. And then all of a sudden the lawsuits start coming because the competitor says, wait a minute, you hired our people, you hired our consultants, and it was inevitable that they were going to disclose our trade secrets and our confidential information into your company. And so your product is informed by our confidential information and our trade secrets. We're seeking a temporary restraining order and an injunction, and the product that you created is contaminated by that other party's confidential information. And that's a very difficult scenario to work your way back out. So my only advice on IP contamination is know who you're hiring and who you're leveraging as consultants. If they've done work for competition, you need to screen that up front. You need to ask those questions. Hey, have you ever worked for these competitors, right? And if they have, you need to be going thoughtfully through a process of saying, okay, well, I don't want you to tell me what you learned. You can't use that at the new company. I assume you have no materials. You need to sign an acknowledgement. You're bringing no materials into our company. And there's a set of check boxes you'd go through with your attorney to say, look, we really want to hire this talent, but they're higher risk because they're coming from a competitor. And make sure that you are asking those questions up front, because once you've been contaminated, it's hard to undo it. It's hard to undo the fact pattern, and lawyers are very skilled at building a narrative that you're somehow contaminated. And then finally, supplier service provider agreements. You know, suppliers want to obviously sell their product or service to you, but they also want to lock you in, right? If they're the only supplier or service provider that you can work with because they've got some really specialized know-how or they've started to file patents in the lane where your product needs to go, you will get stuck in what's called vendor lock-in. And once you're locked in, they can raise the price on you to a point where your source of supply is uncompetitive for your business model. So again, you need to have competent counsel upfront saying, okay, here's how we're going to define IP ownership in a framework. If I have to explain to a supplier my concept or my technical design, they don't get to own the design. They maybe get to own or license some know-how that they're going to build up. But all the new improvements that we have to make in order to get the supplier to build this, those remain ours. Because if they become the supplier, you're going to be locked in with them. Because if you go to another supplier, the first supplier you had is going to sue your second supplier. This is just a big lookout. You don't want to get stuck in vendor lock-in. It's just very painful to extract yourself from that. So I always say, in closing, plan for the end in mind. Like, it's great to do business with other companies. It's exciting to run a startup or work in a big company and do partnerships with others. But plan for that end of the relationship and plan for the scenarios where it doesn't work out. Your lawyers will build in the protections for you. But if you're not at least raising the question of, hey, well, what if I don't want to work with this supplier forever? Or I need dual source of supply so that they have to compete for my business. That needs to be built in up front. So with that, I think I'm at the end of the presentation. I apologize, I went a little over, but really enjoyed speaking with the class, obviously, and all the great questions. Happy to touch on any other questions or comments before I hand it back over to the rest of the class for your portion.
All right, thank you. Nice job.
Right.
Any last questions for Chris? All right, why don't we go to, if we can, let's go to Wearify 1 as the first presentation.
Want to go with Voicesavvy? Can we do Voicesavvy first?
Yeah, we can do Voicesavvy first.
Thanks, Chris, very much.
Thank you, Chris.
Yeah, thanks, Chad.
Yeah,
Thanks, class. I wish you all the success too. Thank you so much.
Voicesavy.
I'm interested in all of this.
I guess.
Just you
I'm sure you appreciate it all.
Yeah, that's what we do every day.
know what, it's snuck in, so.
Yeah, no, usually I'm on it.
Okay.
Very quick, whatever.
So to introduce myself as Joe.
Hi, Jim.
Nice to meet you.
Okay.
Yeah. Let me just.
Okay, Voicesavvy,
Yeah, I wasn't on the Zoom because I was quick, but I'm on it.
I probably should put the Zoom details on the, does everyone have the Zoom details? You can get it on Canvas, so I don't need to put it on the board, right? Okay, good. All right, take it away.
So hi everyone, we are Wearable. We're doing our final presentation. Wait, where's the? Yeah. Yeah. Sorry. So before introducing our solution, we want to first talk about the bigger problem. So today, Parkinson's disease affects more than 10 million people worldwide, including nearly 1 million people in the United States alone. And this number are still increasing as the population ages. But Parkinson's disease is not only a neurological disorder affecting moment, it also increases a large economic, healthcare, and emotional burden on society. So for many families, when one person develops Parkinson's disease, the entire family is affected. So family members often become unpaid caregivers, helping with daily communication, transportation, emotional support, and medical care. And this can be a physically exhausting, emotional, stressful, and financially expensive. In many cases, family may even need to hire professional caregivers to reduce their own working hours, or reducing their own working hours to prevent support. One major reason for this burden is that Parkinson's disease often affects the patient's speech and communication abilities. So patients may speak too quietly, or stumble over words, or struggle to control their vocal volume. Over time, these communication barriers can make normal conversations with coworkers, customers, their friends, or family members much more difficult. And once communication becomes difficult, many patients begin to withdraw from socially and lose confidence to participate in the society. However, there are many therapies can help. One of the most well-known therapy is the LSVT-Loud therapy. This focus on helping Parkinson's patients rebuilding stronger and this therapy trains patients to speak louder and more intentionally, helping them regain clear communication in their daily lives. And this matters because communication is directly connected to the independence. If the patients can communicate more normally again, they may have a better chance to continue working, making social relationships, and take care of themselves more independently. And at the same time, reducing communication barriers may also reduce the society burden in economics, reduce stress on caregivers and family members, which eventually reduce the society burden in economics and healthcare fields. But during our research, we discovered a major challenge. Patients may perform well during the therapy sessions, but may still struggle to maintain those vocal habits once they return home. So outside the therapy, there's no consistent feedback reminding them when they are speaking too quietly. So this is where Wearify comes in. So the Wearify is developing a WAVE, which stands for Wearable Ambulatory Voice Evaluator. WAVE is a lightweight, wireless, and privacy-preserving wearable voice sensor that works together with a companion mobile app. So this device continuously monitors the vocal behavior such as vocal volume, vocal load, pitch, phonation time, and then sound level through the day. So most importantly, the device can provide a real-time haptic feedback. So if a Parkinson's patient begins speaking too quietly, the device can gently remind them to increase their volume and reinforce the habit they learned during the LSVT-Loud therapy.
Thank you, Paul. As Polly mentioned, a huge challenge we see in the current speech therapy journey is that clinicians run the standard 4-week LSVT-Loud therapy protocol with zero visibility into patient practice compliance at home. So this opens up the space for Wearify to create a product that provides vocal data visibility and supports adequate speech volume outside of the clinic. So we look at existing hardware and software for speech support and voice tracking in both clinical and consumer goods, consumer product spaces. For the clinical space, we took Speech5 as an example. This is a wearable device designed specifically for Parkinson's patients. It works by detecting when the user is speaking, and then it will play background noises to trigger patients to automatically speak louder. This device is clinically validated and can show immediate improvement in the speech volume. It's also covered by Medicare in many cases. However, the price is still quite high, as you can see, and the reliance on reimbursement pathway makes it somewhat limited in terms of accessibility and adoption. And for consumer software, we have various types of acoustic apps. So these solutions typically use microphones to capture voice data and analyze the pitch or vocal patterns. They're more accessible and low cost, but the voice capture accuracy is not guaranteed. So based on our research, we believe that Wearify, the wave sensor, provide directly captures vocal vibrations through a network sensor, and it will make it more. It's a more robust solution in terms of separating background noise to users' own voice, and at the same and then also generating meaningful data for a clip. clinics. At the same time, we aim to keep it at a more accessible price point without depending heavily on insurance. So we see wave sensor as a strong solution for the challenge in the existing therapy workflow.
Okay, so our target market. So at the beginning of this quarter, we actually developed explore two different directions for this device. So the first one is the occupational side, which we focus on high use vocal cord in professionals such as like professors, teachers, singers. And the second one is clinical use. We mainly focus on Parkinson's patients with dysphonia and also like clinics, hospitals. So, however, after conducting interviews, we began to notice a clear difference between these two groups. So many occupational users, they don't consider vocal fatigue as a real problem, and they often did not clearly understand how this device would fit in their daily routine, or why they would consistently using it. On the other hand, the feedback from the SLPs, clinics, and Parkinson's stakeholders will be most constantly positive. So clinicians immediately recognize the value of the objective daily voice data and the real-time feedback outside the therapy session. So because of this, we decided to fully shift our focus toward the clinical side. And our current hypothesis is that the wave sensor and the companion app can help Parkinson's patients maintain their healthier vocal habits outside of therapy, while also giving clinicians a better long-time monitoring tools for treatment decisions. So far we have conducted 25 interviews. Some are still pending across both the clinical and occupational segments. And our interviewees include Newcastle's clinical managers, SLPs, and also the Parkinson's patients. We also include some stroke patients just to like increase the patient's field. And from these interviews, we actually discovered several important insights. The first thing is that we realized the biggest pain point is the carryover problem outside the therapy, which we already mentioned previously that we think this might be our biggest selling point. So as I already said, patients might perform well during the therapy session, but they might not continue doing it outside the clinics. The second point is we realized during our interview, many Parkinson's patients told us that the reminder only function is not really useful because it cannot really solve their problem like immediately. So like they do mention like if there would be like a louder speaker or something connected together, that might be more useful. The third thing is we realized that clinicians actually care more about the data fidelity than the patients do, because they might use this data to do some of their own research or like to actually like make decisions. So they maybe care about like how to collect this data and is this data clear enough, and also the data is that like more reliable. The fourth is during the interviews, many Parkinson's patients mentioned that if their doctor recommends they do purchase this, they will purchase this, or something like, oh, I will talk to my doctor if they think it's a nice thing, I will purchase it. So it's more like a clinician-driven adoption, more like a medical device instead of like Aura Ring or something that we saw in the market. Those were minor things. The fifth thing is that caregivers might be a potential buyers. We actually didn't really include caregivers at the first beginning, but during the interviews, because I do talk to many Parkinson's patients, and sometimes they couldn't really talk, so I would just interview people who really is their family member who take care of them. And they mentioned that if this can help their family members, they will consider purchase this. So caregivers might be a future interviewees. The last one is teletherapy might be an unexpected strong market. It just we have already mentioned that in previous slides that this can maybe combined with like clinics to doing like remote like therapies and stuff. So maybe in the future there might be a path of like teletherapy that the clinicians can just like use like Zoom or some remote FaceTime kind of things to like talk with their patients instead of like letting the patient drive like 30 minutes commute to go to the clinics to do the in-person therapy.
Yeah, so the next thing we're going to talk, sorry, I didn't just cut you off there. So the next thing we want to talk about quickly is this kind of macro market landscape. This is something that we were like specifically targeting to do in this project. So we really spent a lot of time in between our interviews and a lot of secondary research as well. So to look at the big numbers, some of these I talked about in the last presentation. I mean, the big number, $41.1 billion in 2025 in global speech therapy, around 5 billion of that being in the US speech market, followed by Asia, which is a growing market in Europe. But the real story is not just that market itself, but specifically where these markets are seeing kind of the greater than normal average growth, annual growth year to year. And that's in this global digital biomarkers market, and as well as the Parkinson's monitor devices market. You have 22% growth year over year. So pretty much exploding in that biomarker market. And we can see that in our daily lives, things like Oura Ring, Fitbits, Whoop, and all that stuff. Specifically here, we're talking about Parkinson's monitor devices as well. Also growing pretty large. Again, this is sort of simplified for the slide, but the important thing to kind of take away here is that there's a kind of shift into the into funding going behind tracking data, tracking health data outside of the patient, outside of the clinic, which you can kind of see here in these market projections. Some other really cool points that we found. Recent trials show that only 8% of Parkinson's disease patients utilize a medical grade wearable for tracking some sort of health. This is a general term. This doesn't just imply voice stuff. Yet 91% report high interest in adopting one if recommended by their clinician. Again, pretty much backing up everything that we just talked about. So while not that many have very many of them now, again, if we get the clinics on board with this, it seems like there's a high interest in at least trying it out. And then another one, Parkinson's disease management increases patient healthcare costs by around $10,000 per year. This could be things like having trouble swallowing, not being able to communicate effectively with either their caregiver or their doctors, fall risks, stuff like that, choking risks. So this is just like from a baseline. You're also just increasing general healthcare costs. So if you're potentially able to rehabilitate people more, able to, in this just one specific scenario, able to get them able to communicate much easier, you could possibly prevent some of these tragedies, but also these costs from incurring. So there's a sort of interest from those paying for medical procedures or medical operations that have an interest in sort of preventing this from happening as well. Now kind of going what you would call like bottom-up market sizing. Your total addressable market here is usually an estimate of 1 million patients, people have Parkinson's in the US every at a given time. Of those, according to the American Speech Language Hearing Association, about 90% of clinical data will tell you that about 90% of those patients have active, clinically relevant dyspnea or other speech disorders, which gives you around 900,000 patients. And again, simplified to some degree. And then finally, to kind of figure out our serviceable and attainable market size, trying to figure out what patients are actively undergoing these sort of clinical speech intervention therapies in a given year. According to the American Speech Language Hearing Association, roughly about 15% of those 900,000 patients will undergo some sort of treatment. These treatments, like Polly said, could either be your 4-week LVST loud therapy or speak out. Some of those therapies continue on in a more relaxed sense where they're weekly group sessions or monthly check-ins with some sort of speech pathologist. So it kind of on a case-to-case basis. This is just a general kind of estimation.
So to actually capture the value that we just presented, we designed a dual-phased commercial strategy. In phase one, we're using a B2B2C direct-to-consumer referral model. The clinician will recommend the device, and then the patient will purchase it out of pocket for $349, the $39 monthly subscription fee. We believe this is a great tactical move because it generates immediate and non-dilutive hardware margins and completely bypasses the standard 12 to 18-month procurement, hospital procurement, and regulatory delays. Our long-term scaling engine is phase two, which is enterprise hardware as a service model. In this case, Wearify Health will retain ownership of the hardware and leases device fleets to clinic for a flat $110 a month per device. The clinic then will use wave sensor during a patient's therapy block, reclaims it, sanitizes it, and then redeploys it to the next patient. The reason why we did this leasing method is that instead of having the clinic directly buy the wave sensor devices up front and then rent them to patients, is because our clinical interviews reveal that therapists absolutely despise managing inventory, handling microtransactions, and dealing with elderly patients' rental returns. So we thought that the hardware as a service model would completely remove that friction. And going to unit economics, this is the basic model. Our unit is one complete wave sensor system, which includes the wearable sensor, the proprietary charger, the component assembly, shipping and fulfillment, and quality assurance and manufacturing. Function research. At the pilot scale, our adjusted device cost is about $227, with an expected hardware life cycle of 24 months. And on top of software hardware, we also estimate about a $12 per active user monthly cost. That's in the software related. Including HIPAA compliant cloud hosting, EHR integration, API fees, and customer or clinical support. So the core economic challenge is balancing a relatively high upfront hardware cost with recurring software revenue over time. And we also created unit economics for the two revenue generation frameworks that I talked about earlier. I'm just going to go through them very briefly. So for the direct-to-consumer model, it gives us an estimated hardware gross margin for about $121 per device, and about $27 in monthly software as a service margin after software costs. And assuming a conservative 6-month retention period, the total lifetime gross profit is around $256 right here per patient. And the enterprise hardware as a service, at the price point, the $110 per active device per month at this price point, after about $9.49 in monthly hardware amortization and $12 in monthly software cost, Wearify Health earns roughly $88.51 in profit per active device month. And then over the device life cycle, this creates around $16.99 in lifetime profit per device. So again, the overall strategy is going to the DTC method, DTC referral first to validate the demand and generate cash flow, and then shifting towards the enterprise hardware as a service model, and then shifting towards this clinic leasing as the software, EHR integration, and then RTM, which is remote therapeutic monitoring, reporting become more mature. We'll talk more about RTM in the next slide.
Is your way to wrap it up? You've already gone 20 minutes.
Okay.
Yeah, we have like 2 more slides.
Okay.
Okay, so the actual ideas here is this idea of remote therapeutic monitoring. These are, again, simplified for the presentation, but there are basically different types of codes that SLPs can use to basically make a profit off of this device. So the idea is that once we move to this, enterprise model, things like initial system setup, basically wearing, as long as the patient wears the device for a minimum of 16 days in a 30-day period, and the first 20 minutes of monthly data review. for each, the first 20 minutes of monthly data review on an SLP side, they can actually bill insurance for this. And so the idea is that if they're leasing it for at less of a cost, or $110 a month, and they're able to, this is just a few codes, while there's more codes based on how often the patient wears it, how often you're actually meeting with them, you can actually earn a profit using this device. And if Neurolux-Held is dealing with the entire side of administering devices and sending them out and cleaning them, there's very little on the SLP side that they need to do besides what they were already doing and providing better patient care by using the actual data that's been collected. So it's also basically a way to profit for the clinic as well, and that's a way to pitch them and to get SLPs to get behind it. I'm going to skip this for now. Pro forma income statement, just some estimations. The important thing here is that basically over time, profit becomes much easier because you don't have to build a device for every single sale that you make because you're able to use the reserve. And that even in a size of even just like expanding to 50 clinics after a couple of years, it could be profitable as long as they're administering them to patients. Two, looking at like the long term, we have two other kind of niches that we would have wanted to look at if we had more time. One is the athletic coaching niche. It's basically the idea that while maybe on the occupational side, teachers and small businesses weren't really as interested as we thought they would be, athletic coaches have high discretionary budgets and a really high rate of severe occupational voice disorders. And oftentimes, especially for think of like your head coach of an NFL team, they need to be able to speak and do press conferences. And so a team or a company would have a high interest in paying whatever they needed to maintain that. On the other side, there's some other clinical applications, stuff like stroke recovery, cerebral palsy, traumatic brain injury, and just other sort of surgical and vocal fold paralysis rehab. And so I think that kind of wraps up our presentation. The main thing here to build a kind of really, really stable and long living business is the idea of this data aggregation. So through Parkinson's, possibly through the other niches as well, Vizzuto would be able to like kind of build a very, very strong, not just hardware market, but the actual proprietary software algorithms that they're using behind it to expand to kind of whatever application they can and use that to inform whatever decision they make. So,
Right. Thank you. Nice job. Very detailed, very thorough. Any comments from the clients?
I have a couple of questions, although I know we're running tight on time.
Okay.
So first is regarding pricing. $350 for the hardware, and then I don't remember what the subscription was. It seemed very ambitious. Have you validated that?
Yeah, I think so the idea on the DTC side was small pilots, but for people who really are interested in a device like this and testing a device like this, from when we talk to people, I would say most of the, at least caregivers that we talked to of Parkinson's patients told very sad stories of, someone who really loved social events. You went out to dinner in a restaurant, they'd be the life of the party, to kind of almost like not really interacting with people, not just because cognitively they couldn't, but because they didn't feel that they were able to like project their voice and make their voice heard. So they kind of just stayed silent. And especially, I think someone I talked to last week said their father had voice issues for over 10 years. And if you could say, here's $300 and, you could be able to kind of restore that a little bit. I think when we asked, she said, I would pay $1,000 for that. Like when you really sell them on how this is going to make an impact in your daily life, I think that can go a long way. And as far as medical devices go, it's kind of at the lower end, especially compared to the competitors. But the ideal scenario would be kind of using that $349 per device as kind of a pilot study. Obviously not charging people in the beginning, but just to kind of aggregate as much data and users as possible, and then moving toward that enterprise model where Medicare ends up essentially paying for everything, and both the clinic and the company profit off of it.
Okay. And then the last question I have is, it seems like you guys were recommending, and it's a good wedge, is to go through the clinics, then the clinic recommends that the individual patient or caregiver buys. but the actual active Parkinson's patient population that's in speech therapy is about 30,000-ish. But there's about 900,000 people that actually suffer from voice issues because of Parkinson's. So I'm wondering, where do those other like 850,000 people, how would we reach them? Because this could benefit them as well, not just the 30K who are in speech therapy.
For sure.
I can answer some because I've talked to like some like interview I done. It's like I just basically call people that from China that they've never heard about LSVP, like this therapy, but like the probably it's slightly different in China, but basically they just go to the hospital to do this and they just got recommendation by their doctors. So that's why I said like it's not like clinicians. I mentioned doctor, just like no matter who like treat them, like they will more trust them. So it's I don't think we need to limit only on like LSVP allowed clinics. Can be like broader.
I think a lot of them are in assisted living facilities. I mean, my dad was, suffering from Parkinson's for 20 years. 15 of those years, he was in a NICU. So,
yeah, even patients who their family members died pretty recently, a lot of them didn't know about treatments like this and were like almost excited hearing about just the fact that the treatment was a thing because they didn't know and they thought that would have been something great for their loved one. And even when we talked to the people who run Speak Out, which is like kind of a competitive competing, but similar therapy, they're still working on expanding, and they're only available in about half the U.S. states. From that, the chances that you have a clinic in a city near you and you can get it into a patient is still not that easy. So I think it's still a growing treatment, and so this goes along with the treatment, so it can scale with that as well.
Absolutely. Thank you guys.
All right, nice job. Yeah. We have food outside, it's waiting for us. So why don't we take a quick 10-minute break? It's boxed dinners. I would ask Neurolux if they're willing to go next, only because we have Buell online, and Buell is halfway around the world or a third of the way around the world. So 3:30, 4
or something, I think, right?
Yeah. I mean, we can get them to bed by 1:30.
Yeah, there it is. Yeah.
So we're going to be back for you, Buell, in about 10 minutes.
Hey. Yeah.
The Met track.
Hey, how's it going?
It's like oh, just a second.
Oh, okay. Wow.
It's pretty cool.
Yeah.
I was kind of like
Congratulations.
on me.
Yeah.
Oh, I'm not on it.
You're not on there.
It's my best friend.
Oh,
okay.
And so I was wondering
How
how
did
it would
that
work.
Okay.
And she actually didn't have a concrete device. She has this solid idea, but she not explain that.
Super familiar. What was the concept again?
It's against
Like
the
smoke piece device. So,
hydro.
so
About
yeah, sure. No,
perfect.
trying to think about what this is.
I think Rayos was a competitor.
Rayos won a few years back.
Yeah.
A while ago now. Yeah. They already had a competition, or they're in the finals, or what?
This is like the venture cat was right out like during class hour.
Oh,
So this was in the back. I
I
had
see.
like
Yeah.
1 year in just like going for it next
Okay,
year.
yeah.
So here you can see.
Just kind of a concept around.
Yeah, so I was looking at each one of them and hydroflow. One out of all of them, it's the perfect rule.
Oh, wow. Yeah.
That's
So I just wanted to let you guys know about what great favorite. I
I do.
Oh, okay. Where who are they?
she was here actually. She has nothing to do with it. She's doing health next year. And she's just her brother got that, and so everything that was her passion project, and she brought it in here. This is my other guy friend from before. They recorded, yeah, I can send over the link. But I was just wondering, if, I mean, I would always talk
in-house.
Sure, yeah, it just comes up every year.
Every year.
Yeah.
I mean, I would try it out every year. So
It's a good feedback through that process.
the first one you kind of watch, I talked about it like in my application. It's kind of very watching it happen. But yeah. Awesome.
It's funny, it's, we entered that competition, and what I didn't realize is the first place winner, it was a company called Sensible Device, a couple of mechanical engineering graduates. So I advise you to put your fingers in it and then go computer coordinated with basically so you can create you know who the guy was who was leading that effort? The congressman from Kentucky who just lost the primary.
Oh, wow.
Thomas Massey.
Who is it this?
That's so weird. Because we got all the way to the finals, and then each of us got up and gave a presentation. Big audience, stuff like that.
That's good. Would not have made that actually.
Yeah. Those are great games. Perfectly. Wow.
Again.
Wants to come to class with me actually Wednesday night. I want the applications are. Probably get going. We get started?
Yeah.
If Neurolux is ready, come on up. Neurolux, come on up if you're ready. I've recorded all the presentation. I think there's a problem if it gets to YouTube or something. Yeah. Should have some clients next time. Yeah, I'll send it. All right, guys, if you're ready, take it away.
Hello everyone, so we are Neurolux, and here's our team background. So we divide our team to two parts. So one part is for the bone and one part is for the dog. So we will start for bone part first. So modern dairy farms are increasingly good at monitoring what cows do, such as eating, behavior, rumination patterns, and activity or movement. But a key challenge is that behavior alone does not always explain how cows are physiologically responding to weather stress. For example, in
heat stress, overeating, discomfort, or early welfare changes, a cow may already be experiencing physiological strain before the behavioral change becomes obvious to be farmer. Most existing behavioral monitoring systems primarily track activity patterns. That is useful, but it may not provide enough physiological context to understand the cow's true welfare state. So the missing layer is physiological welfare context. That is the gap Neurolux is designed to explore. Existing system monitor what cows do, but the Neurolux explores how cows physiologically respond. Yeah, so we still want to show our system, like Neurolux focus on adding deeper physiological welfare visibility through respiration-related patterns, heart rate, and movement-related acoustic information. The goal is not simply to collect more data, but also to provide farms with richer physiological context about how cows respond internally to stress and welfare conditions. So to address this gap, Neurolux combines several sensing approaches in one wearable system. So the first layer is for the emotional sensing, and the second layer is for the physiological sensing, and the third layer is for the mechano-acoustic sensing. The important thing is that these layers are complementary, which is not like divided into three parts. So we're not trying to replace the existing behavioral monitoring systems. Instead, Neurolux extends them by adding continuous physiological welfare visibility that current system may not directly capture. Yeah, so our initial target market is for the welfare-driven dairy farms in Europe. We select this area like Netherlands, Denmark, Sweden, and Finland because they already have a high adoption of precision livestock farming, robotic dairy infrastructure, and strong focus on the welfare compliance. And for our interviews, help validate and refine this market hypothesis. Our stakeholders confirm that behavioral monitoring is already well used, but there is interest in welfare visibility and per-stress monitoring. So our key business hypothesis is that farms already developing behavioral monitoring may be willing to pay for an added physiological welfare layer. In particular, we believe there's demand for systems that provide richer well visibility, reduce manual well assessment, and continuous physiological monitoring integrated into existing workflows. And here's the map for our competitive position. So we divided to two parts. For those is for the behavior monitoring, and for ours, we select our into the physiological welfare market. The main difference between our market with other monitoring systems is that they only focus on behavioral, but we focus on like more about the physiological welfare. So most current systems primarily focus on like it includes the stress-related physiological patterns, respiration-related monitoring, and continuously physiological contact beyond activity data compared with our product with the other monitoring system. So the differentiation is not simply more than sensors. The differentiation is the type of welfare visibility being provided. So our one of the most important insights from our interviews was the farms are not necessarily asking for AI diseases prediction systems. Instead, many stakeholders were interested in technological that provide continuous physiological welfare context. So current systems mainly under the what is the cow doing? But for our system help to answer how is the cow physiologically respond. So our interview feedback also suggests that behavioral monitoring already dominates the industry, but for the physiological may provide additional welfare insights, especially for stress monitoring and for the welfare visibility. So this leads us to reposition Neurolux not only as a standalone disease prediction platform, but also as a physiological welfare extension layer that integrates with existing precision theory ecosystems.
So for our initial beachhead market, we're focusing on welfare-oriented dairy farms in Northern and Western Europe, which is the major dairy market and plays a large role in the global dairy trade. Since Neurolux is positioned around animal welfare and monitoring beyond behavior data, we want to start in markets where animal welfare regulation, precision livestock farming adoption, and robotic dairy infrastructure are already strong. So farms in these regions are already investing in automated systems and behavior monitoring tools. This means that they already understand the value of data-driven farm management. Our hypothesis is that this farm may be willing to pay for an added health monitoring system if it helps them better manage and understand the cows. So the opportunity is not simply to sell another sensor, but to add more welfare visibility beyond the data. One of our key strategy decisions is that Neurolux should not only be a standalone wearable system. The market already has mature platforms such as the Lava. So instead of asking farms to replace what they already use, Neurolux can also add as an add-on to the existing platforms. We can see two possible revenue paths here. The first path is direct sell to farm. In this model, our consumers will be welfare-driven dairy farms. They will purchase or lease the Neurolux hardware, then pay a subscription fee. There may also be an installation and onboarding fee. This model is especially useful for early pilots because it allows us to test the product directly with farms and learn how they do with the data. The second path is the platform integration. If a farm already uses a management system like the Lava, Neurolux could add health monitoring context on top of the operational data that they already collect. This gave us partnership opportunities through the API integration, OEM, and welfare analytics add-ons. So our long-term goal is to become a complementary intelligence layer inside the existing theory ecosystem. So for unit economics, we build a single pilot deployment model based on a few assumptions. We estimate the hardware price at around $150 to $200 per device. The subscription fee will be around $5 to $10 per cow per mouse. At the beginning, we would focus on high-value or high-risk cows, such as cows in transition period or previous health issues. Cost structure has four main parts: manufacturing, infrastructure, analytics, and support. Hardware revenue comes from the initial device purchase, expansion, and replacement unit. Some software as a service revenue will come from the welfare dashboard, alerts, and analysis. Partnership revenue will come from the platform integration, OEM agreements, and licensing opportunities. So the hardware could help Neurolux enter the farm. But the more scalable and defensible revenue will come from the recurring monitor, analytic, and platform integration. So in year one, we assume a very small contract with 2 farms and around 1,000 devices. At this stage, costs are higher, and the goal is mainly just about validation. By year 3, we begin to reach in scale with 30 farms and 15,000 devices. Then in year 4 and 5, the model grows more significantly, reaching 160 farms and 80,000 devices. The reason the economics improve over time is that both hardware and service costs become more efficient at scale. The hardware costs will decrease from $48 to $35 per device, and service costs will decrease from $30 to $22 per device. As a result, the total contribution grows up to $12 million by year 5. The exact number are assumptions, but the strategy message is clear that if Neurolux can scale through existing dairy ecosystem, contribution margin would improve as production volume increase. Infrastructure would become more efficient and recurring analytic revenue would grow as well. Finally, it's our 5-year roadmap. In year 1, we will focus on validating the key signals. We will also need stakeholder research and data collection, then move to MVP and pilots. This means refining the wearable device and dashboard, running early phone pilots, and testing whether the system fits into real phone workflows. In year 3, the focus becomes platform integration. This is where Neurolux begins connecting with existing current management systems. Later, when we scale, including expanding deployment volume, improving welfare analytics, and launching through distributors or platform partners. By this point, Neurolux should become a more mature add-on. In year 5, we should expand beyond the initial dairy beachhead. The technology should be adapted for goats, sheep, and horses, and we could also expand into new regions and markets. The long-term vision is to evolve from a validated sensing prototype into a partner-integrated physiological welfare platform for precision dairy farming. So overall, our strategy is to start narrow, prove value, integrate it into existing systems, and then scale into broader livestock welfare intelligence.
All right, so for the dog device, I'm going to go ahead and get started, tell you the basics and some of the interview information, and then how I'm going to go into a lot more detail, especially on the market analysis type thing. So the device is pretty much similar to the bovine one, but it allows you to answer the question of, what's my dog feeling? And of course, everyone wants to know that, everyone being the 70 to 90 million dog owners in the US. But there's a couple of particular populations, I'm going to go back to that slide, a couple of particular populations who would want to know that more. New dog owners and the opposite, owners of old and sick dogs, and then show dog owners. So back to here, the device, pretty much the same, accelerometer, contact mic type of thing. And from there, read heart rate, respiratory rate, and you can monitor activity, sleep, running, scratching, those types of things. So there are existing products in this space. All of them are pretty much a collar attachment. And the accuracy of these devices is a little nebulous. One in particular I clicked on, they had a link on their website for a spec sheet. Didn't say how accurate their readings were. It basically just said three-axis accelerometer, and that's not very helpful. So this device far more accurate, just because the technology is better, and also it is an implant, at least in its current state. So all the existing devices have to read through fur and skin, which is going to give you a little interference. This second point is pending, but vet integration, this implantation of this device will require vets to at least agree to implant the device, which if a vet is agreeing to it and actually doing it, a customer is going to have much higher trust in the device. So as I went over before, these three populations of dog owners are the most invested in this type of device. But two main roadblocks here. First, that it's an implant, and more than half of our interviewees were just completely unwilling to consider an implant. Most did prefer a collar, but would at least consider the implant, but many just said absolutely not. This could be mitigated somewhat by pairing the implantation of the device with another operation, especially a sick dog. Sick dog is having surgery, something already. Might as well just throw in another thing. Also, cost. With an implant, going to cost more just right off, and some of the existing devices are up to $500. Also, pretty much every interviewee hated the suggestion of a subscription, but for analytics, but that's just how we got to go. There's a variety of products on the market already. Sales, a little hard to find. Got a number of claimed users from either their website or their LinkedIn or something, and then actual app downloads. Pretty sure the Android downloads are going to be less than half, but Apple numbers aren't easily efficient. All of these, again, are collars. There has been one implant device that was publicized, but not available. Looks like a company that doesn't exist anymore. So a couple of points from interviews. Very few people just said, no, I'm not interested in this. One, they're retired, but they're always around their dog, and they're pretty in tune with the way the dog feels anyway. The other person, similar. I don't need this. I can just look at my dog and know how they're feeling. Again, the preference for collar. Very few. I'd go either way. Some people did prefer an implant. I thought the most interesting thing from the interviews was a couple of people had an expected price in the thousands. They wouldn't be willing to pay that much, but that's what they would expect. Subscriptions, even though most people would prefer not to, highest range that we were given for a monthly price would be $50. It was a little difficult, very difficult getting vet interviews. I sent several emails, rounds of emails, but I only had one return. And then one of my last interviewees also was going to refer me to a couple of show dog owners who, again, more likely to be spending more. And I believe, yes, this was a plot for the information we were collecting. We made computing matrices of some of the information. This was the most interesting one, I thought. And then this one has all of it. It's unreadable. I just thought it was interesting to throw out there. And now I was going to go into more details on learning.
Okay, let's move to the market opportunity. So there are around 75 million dog-owning households in the US, and the pet owners are spending more and more on health and wellness products every year. We think the most realistic early adopters for our product are not all the dog owners immediately, but more health-conscious owners, especially people with senior dogs or dogs with chronic conditions or multi-dog householders. These owners already spend heavily on wellness care and are more open to continuous health monitoring technology. So our strategy is basically to start with this higher intent users first, and then gradually expand into the broader consumer market. As for our value proposition, the main value of Neurolux is reducing the uncertainty for dog owners. So from our interviews, we found that most owners already paid close attention to things like their dog's sleep patterns, their appetite, and energy level. But many said they still struggle to know when something is actually serious enough to call the vet. Neurolux continuously tracks signals like heart rate, respiratory rate, temperature, activity, and sleep patterns, and then turns that data into kind of simple alerts and insights for dog owners, which could be really helpful. And compared with products like Big Bark, Neurolux is much more health focused because we can get like more complex data and translate the data into simple alerts for dog owners. And compared with Cactus, our positioning is more focused on the long-term continuous health monitoring through the implantable form factor. And this is our business model description. So our model basically has two revenue streams. First is our implantable device itself, which we estimate would be priced around $179 to $249. Depending, and our final price will depending on the final positioning. And second is the optional premium subscription, which would provide advanced analytics, the long-term trends, and some special rewards for dog
watch with Bobby Jones. $149 to start LOSing. Wait now. Markwalk2000 at yahoo.com.
Sorry, that is.
So we expect the bad recommendation to be a major driver of adoption because trust is especially important for such an implantable product. So even though we may use direct to customer marketing for awareness, the web channel will likely remain a core part of the business model. And here's the unit economics. So even using relatively conservative assumptions, the model looks really attractive at the customer level. At the early scale, we estimate around $85 COGS per device with a blended CEC around the $65. And the combination of hardware contribution and subscription value gives us an estimated lifetime value to CAC ratio of roughly 4.5 early on. And then with the further improvement as manufacturing scales and the retention improves. The key point here is that the business does not rely only on the massive scale to work. The customer economics are already reasonable even in the earlier stages. And here is our financial projection by year 5. We expect slower adoption at first because the implantable form factor creates some friction and requires strong trust and also the involvement with the VAD's recommendation. However, as awareness grows and manufacturing scales, revenue increases significantly over time. We project the business turning the operating income positive around year 3, while the subscription revenue gradually becomes a larger part of our overall revenue. Overall, the long-term model becomes more attractive as hardware costs decrease and the recurring subscription revenue grows. Yeah, here's our final presentation.
Thank you. All right, any questions? Joel?
Yeah, well, for the last thing, the PET thing, the PET sensor, how big is it? Because if it's more than 2 to 5 millimeters, customers won't accept to implant it.
Yeah, so anything larger than like a current microchip, which doesn't require anesthetic for getting implanted, would require that sort of operation as well. So that was something from that size. I believe the size that I was told was like twice the size of a microchip in that range.
And how do they charge them?
Similar thing to a wireless phone charger. One of the options would be to embed the charging coil in like a crate or a dog bed or something like that.
Okay, so, thank you. Okay. For Lynn and Joao, first, the cows and the dairy market were not your field of experience. And I say it nice then. But you've done a great job. You'll always remember, you will always remember in the rest of your life, these 10 weeks, anytime you look at a dairy farm or at a dairy product. I'm sure. My first question is, what was really new for you? What was there? Is there a key discovery that you didn't expect at all when you started? And the second is, what is your advice to us?
So what we didn't expect, like for initially we found that for those current dairy monitoring, it's already like very strong in behavior tracking. So that's why we want to set our Neurolux as a what is that called? Complementary layer instead of like a standalone monitoring, like still like compare with those behavior monitoring. And what we fund for this like quarter is like so I think it's a great way to speak with the other areas people with this kind of product. So I think that is something we will learn. So if we like I think it's really helpful for us like to make the other interview with like different area person in the future. That's
As a former dog on the dog side, I was going to ask, can you measure or assess somehow whether the dog is in pain? Because that's one of the biggest concerns, I think, for older dogs or maybe sickly dogs. How much pain are they in? I hate to say it, but at what point do you just say enough's enough? Put them down. Is it possible to measure something like that, or to infer it from the measurements you have?
It's not something we've discussed specifically with Cameron, but one of the existing ones devices does say it can measure pain, and that's just an external device. So it's got the interference off breathing. And in addition to that, you could certainly find just from activity, like a sudden, like you've got a joint issue, tweak it wrong, dog's going to move different. That could be extrapolated.
Okay. Thank you. Yul, anything else from you?
No, thank you.
Anyone else? All right, nice job. Thank you. We can move on, I think, to Wearify 1.
Feel free to sign off, Boulay.
It's been a long
done your duty. Yeah.
Yeah. Let's talk about horses. Talk about horses later.
Horses next. Yeah.
Is there really any horse?
Yeah.
Students for horse lovers. Exactly.
Yeah.
We'll know the right thing counts. Have another good questions they ask. This is not a cow crop.
There are too many cows. They didn't have to.
Okay, take it away.
Hello, we're Wearify Group 1. I'm Erica.
I'm Yuya.
Maxie.
And this is our final presentation. Okay, so oh, it's not moving. Okay. So overall, our proposition was to find out how valuable this modular sensor would be in the commercial market. And overall, the issue is that right now, clinicians are evaluating skin using a subjective test, which is by the hand. And our sensor allows an objective data point, which is unlike anything else in the market right now. So our client wanted us to kind of scout the market landscape to understand what the competitors were doing and what clinicians wanted and what customers in the retail market wanted from our product. And so what we did was conducted rounds of interviews, asked both retail customers who were in the luxury section of the skincare market, and we contacted clinicians and sort of those who are estheticians in the middle ground between customers and insurance. So overall, we kind of discovered that there is not much value in the retail market as customers aren't super interested in what this product has to offer, but clinicians were most interested in estheticians who are kind of unsure or thought that it would conflict with the options to take about it. So what our sensor measures is the modified Roten skin score, which allows clinicians to give an objective score for that scale. So right now, clinicians on a scale of 1 to 10, they feel the skin by hand, and this measurement can vary from clinician to clinician. With our sensor, we can provide an objective score that could be averaged across dermatologists and would be useful rather than differing from dermatologist to dermatologist. And right now, we have around 300,000 US patients that are suffering from skin diseases that would be valuable for our sensor to measure, especially we were told children would be a big market, as parents often are very motivated to help their children, especially if they're suffering from some sort of skin disease. And we approximately guess at the market segment that the sensor has if it's correctly utilized and connected to the patients and would sell it to their patients. So this is our product, and we are thinking around $20 to $50 a unit. But of course, if it's more in the clinical side, then this could go up a lot. But I guess this would be kind of in between where we want it, especially around production, which is kind of TBA on our client side because we're not really sure as it's a smaller startup. And overall, what our product provides is kind of a longitudinal data like aggregation. So it's really useful for clinical trials, at home wearable tracking for patients with diseases. And as it's very small, it's very easy to stick on the skin and apply and take off. And so it's really useful, especially we're thinking in pharmaceutical applications. So right now, what are our benefits that our product has over its competitors is that pretty much there's nothing else like our product on the market. But on the retail side, there is not much of a demand for it. But overall, as mentioned earlier, pharmaceutical really likes our products. It's very useful for clinical trials. And we met with a couple of dermatologists who said that this would be very valuable over using they currently use to measure skin.
So it's a little bit deeper into market analysis. So for this slide, the main point is that we did not choose the biggest market paper. We chose the market that Wearify has the clearest. So at the beginning, beauty retail and influencer validation looked very attractive because the TAM's numbers are very large. But after customer discovery, those segments showed a lot of friction. So consumers were anxious about tracking their own skin, and Mansplus did not see modulus data changing their treatment decisions. And brands were cautious because objective data could expose weak product performance and also negatively impact their sales for a long period. Disease management become the stronger entry point because it combines market size, growth, and real clinical need. It has the highest growth rate among our addressable segment and a very large SOM. But more importantly, dermatologists could immediately name specific diseases where stiffness actually matters. So our recommendation is to enter through disease monitoring first, then use that clinical evidence base to expand to pharma clinical trials later, once the technology is more validated. This slide shows why we believe Wearify's skin modulus sits in a blue ocean tissue. There are existing tools that measure skin or tissue properties, but none of them combines the three things that matter for our use, which are a blue modulus outputting capable, a soft wearable form factor, and a price point below $50. For example, Capander and Visia are established devices, but they're expensive, less portable, and mainly used for skincare R&D or aesthetic settings. The acoustic wave patch, which is under development, is closer in form, but its focus is mainly in muscle fatigue and wound healing, not dermatology disease monitoring. That gives skin modulus a very specific use. It is not just another skin measurement device. It could be a low-cost, portable monitoring tool that can bring objective stiffness data directly into clinics and eventually into remote monitoring workflows. So this slide dig deeper into the evidence behind our pivot. In our first phase of interviews, we tested consumers, retail, med spa, influencer, and clinical market. Most of the consumer-facing segments had their problems. So consumer did not really want to own another device that might increase skin anxiety. During one of our interviews, the interviewee made an analogy that this data could feel like another calorie tracking app, and they don't like the feeling of being manipulated by this data. And NetSpus told us modulus data would not change their recommendations because the current established device Visia could currently fulfill all their needs. And brands and influencers like the idea of objective validation, but they were also worried that the transparency could work against them. The strongest signal came from clinicians, as we mentioned before. They did not speak generally, but they named specific diseases like morphea, scleroderma, lupus, and keloids. This is where tissue stiffness is directly related to disease progression, and some of the diseases has a large portion of pediatric patients, where the data could be especially helpful because it made communication more efficient, and also because parents are so eager to know everything about their kids' condition. After the pivot, we interviewed more clinicians, patients, and patient parents. The responses were much stronger. 9 out of 10 post-pivot interviews were positive. That told us the clinical market was not just theoretically attractive. It had real demand from both providers and patients who want objective proof of a condition is improving.
So, as mentioned before, so basically, there are several assumptions for a clinician to route our product to patients. Either our product has solid clinical data, or we have FDA clearance, and currently we have none. So this is our proposed business model for the current stage of the company. We firstly sell our product to the clinics directly instead of we have a B2B. We should have a B2B model instead of a B2B2C. And the reason behind this decision is because we need to generate revenue as soon as possible so that we can have enough cash for us to basically sponsor us for FDA clearance or clinical research so that we can achieve our final goal, which is like B2B2C model. And so the current model is like we sell directly to dermatology clinics, not the patients. It's like a software as a service subscription, but with the hardware included. The core offering is a $4.99 per month platform subscription, which gives clinics access to the modular dashboard and for these to reusable sensor pods. That monthly fee is the engine of our recurring revenue. And on top of that, we have a usage fee of $5 per completed report. In our base case, the clinic runs about 50 reports per month. That's additional $250 in our variable revenue per month per clinic. And there's also a $500 one-time onboarding fee, which includes engineering, sales, tutoring, teaching you how to use our device, and demo kit shipping and provider setup, etc., etc. Basically, we're not profiting from this. This is just like the average number that we researched
that is required to hire a engineering sales and to cover up our cost. And looking ahead to year 5, by then, supposedly we will already have FDA clearance and tons of clinical data. We can expand our business to pharma and clinical trials, and this will give us another boost in our revenue to around 102,000 per study, structure as like setup fee and plus per site and per patient fees, data analysis fee, etc., etc. And this is our unit economic models, and revenue side is pretty straightforward: $499 for the platform lease plus $250 from reports, and this gives us $745 total per clinic per month. And on the cost side, we have a hardware amortization, a replacement reserve, and disposable interface materials, and the cloud and app hosting, and the customer support and payment processing. That will be 173 total variable cost per clinic, and this leaves us a monthly contribution of 576, a 77% contribution margin. And now for a customer acquisition, we're spending $252,500 per clinic to acquire them. That covers sales hours, demo kit, and marketing, and the money that we spend to maintain our relationship with the clinics. And with a 576 coming monthly, we will cover that investment in 4.3 months, and over 24-month gross contribution window. The lifetime value to customer acquisition cost ratio is 5.5. That's a pretty strong signal if our calculation works. So this is our 5-year finance picture, and year 1 is deliverably pretty small. We are entering the market as wellness monitoring device to clinics, which means no FDA clearance is required. We're targeting 10 clinics and projecting 54,000 in total revenue. This is like a proof of concept. We are validating our commercial model, now scaling it. By year 2, we are expecting acceleration here for $49K in revenue across 50 clinics, and also we decide to expand our market to the C side, to the customer side in this year. And year 3 is heavily investment year. R&D peaks $1.8 million as we run our pivotal clinical trial and prepare for our prepare to scale our C-side sales. And year 4 is the inflection point. We're projecting to unlock our pharma CRO channels and accelerate our revenue to around $111,000. Yeah, that's it. Thank you.
All right. Any questions for the team?
Just one question about the $50 or less, $20 to $50 for the device. Like, where did that number come from? JK focus. Really?
Yeah.
No, I mean, that's how much you would sell it for? You know what I'm saying?
Oh yeah. Yeah, this is when we finally reach the stage of like to see. I mean, according to our interview, people don't want to pay a lot for those skin condition monitoring. It's not like some fatal diseases, they said. Yeah. So we were just like randomly came out with the device where we will make our products professional but still cheap at the same time. So
I don't know. These are all just like projections, so we're not really sure like what it will end up to be. But if it's dermatology, then like the price could be much higher because it's straight to clinical. But as clinical trials we discussed before, like you can charge an exorbitant amount because it's for pharmaceutical and they have deep pockets.
Yeah, overall I think the presentation was good. It was nice and thorough. I think that pricing across the board is probably really low from what I experienced, and especially with the clinical trials and then also with the device itself. But I think everything, just plugging in the right numbers, and I think the scaling and how you have it, divided out is good, and you can plug those in later.
The consumer feedback was very consistent. Nobody wanted to pay, or were there certain instances, perhaps?
There's a certain instances. People say they want it, but they also ask a lot about like whether their insurance plan can cover it. So that I'll take that as a signal that they don't want to pay a lot.
Or that they're trained not to pay for medical services if they have good insurance.
Right.
Yeah.
I would think of parents would definitely, especially parents of children who are affected by this, would probably want to pay. People whose behaviors or lifestyle is impacted by their skin condition.
Right.
Yeah.
Inability to swim, inability to go out, and inability to be with friends outdoors, etc. Those are examples where maybe the technology would help them.
Yeah, I think the price would be highly variable across whichever market that we offer this product in. For example, pharmaceutical would be very high, and then clinical a little lower. And then for retail, probably 200 around that range is probably acceptable for medical device. And we found that like around skincare and estheticians, some people found it would be like a fun gimmick, but I'm not sure if you'd be like a consistent repurchase that it'd be safe to offer it at retail.
Any other questions? All right, thank you. Nice job. We're going to close tonight with Wearify 2.
Yeah. Make it up
We've got a couple of smaller.
And my wife's also makeup. I'm sure that's something that actually has a battery. It's just like what you really got to do. The courage was to interchangeable. Oh yeah, foundation. Right. Yeah.
Okay. Are you sharing your screen?
Yeah.
There you go. Perfect.
Hi, I'm Dongyuan. Today I'm presenting Wearify's blood sensor. And this is our market opportunity and business model, final business model canvas. So first, the company Wearify a startup from Western Reverse Lab and developing this small battery-free continuous transepidermal water loss sensor about size of like a quarter for skin barrier monitoring. And our product's core strength is patent technology and clinical validation from Northwestern. And the Wearify second, the customers. We serve three customer segments. Primary is the mass and the athletic consumers seeking objective recovery data. And secondary is dermatology clinics needing remote monitoring tools long term. And we target hospitals and the ICUs for critical skin failure monitoring. And third, the competitors. Direct competitors include Coraja and Kazaka and Delphin with handheld transepidermal water loss probes. They have clinical credibility, but are clinical only and a single point. Our differentiation is continuous battery-free wearable monitoring, and this is the first of this kind. And also, Wearify's plug sensors objectively track skin barrier repair and starting with post-procedure recovery in aesthetic medicine, including laser, medical peeling, microneedling, and surgical incisions. This naturally expands into wound surgery for burns, diabetic foot ulcers, pressure ulcers, and the post-surgical incision management. The core monitoring logic is assessing the barrier repair and wound healing, and then infection risk applies to similarly across both fields. So it will help to transition markets. with this continuous monitoring device. And then, so this is like a summary of the 4 type of interview categories. First one is the patient outcome and the pharma experts. And firstly, from these sections, due to the interview, that current objective scores like ESSI and score it have high availability and recall bias. And the marketing clinical trials data is unreliable because dermatologists lacks of the urgency of life-threatening diseases. So FDA acceptance of digital endpoints is low. Evidence must prove it's improved itchy or sleep or any quality of life can be improved by using the device. Otherwise, as one expert said, if it doesn't improve anything, it won't be used. And data security, repeatability, and discrete designs are also mandatory for FDA approval. From the second segment is the med spa marketing experts area, also including the med spa consumers. For those parts, patients have like issues with like post-procedure anxieties, like is my skin healing normally? And the clinics like experts are saying there's no objective data, only photos and the verbal reassurance. There is no ability to remote monitor recovery. Patients disappear with leaving the clinic, hurting retention and repeat visits. There's like a gap between visits, and this is difficult for them to keep on track the conditions for their patients. So also young patients are sensitive and visible to the visible device, and they're concerned about wearing this bulky and not visible monitoring. The core need is objective data to reduce anxiety, lower compellence, and increase repeat visits. And for another section, I interviewed for like skin issue consumers, including sensitive skin, eczema, and psoriasis. They cannot tell like if the skincare product is actually working, so they wanna have a device that can tell them there's like any like product or ingredients that is chemical or affecting their skin health. And also they want to have like a quick feedback to show like how much their skin condition looks like. And for long term, and they don't know if their skin is improving or have any issues, they're willing to see like any like tracking or prevention kind of thing for Wearify system. And there's consumer are saying, I don't know if what I'm doing is working. I just guessing because of for dermatology skin issues, they usually patient just by looking at their symptoms on the surface, their skins, and they're willing to adopt like simple non-invasive tools. And the last sections for dermatologists and clinicians, and they have addressed issues like for dermatology, skin issues is not like life-threatening conditions. So if we go to something like unsolved, such as diabetes, ulcers, burns, SJS, and these are lacking of like continuous monitoring methods. And also missing like early change can be like fatal. So existing transepidermal water loss tools are clinical bound, and episodic can be helpful if this is something we can address our market to that directions. And so also if we're looking into the markets for like a more like life-threatening conditions, they do have issues between like gaps, like between visits, and they can be cause a lot of serious problems, life-threatening problems. But we do need to have this clinical evidence for FDA clearance and discrete designs. Yes. And our business
model canvas summarize how Wearify create, deliver, and capture values. So our priority is the med spa, and the second priority is dermatology clinics, and third one is the hospital and ICU in future segments. And for med spa is making the post procedure recovery visible, and for clinics is remotely monitoring patient barrier trends, and for hospitals are early warning before skin deterioration, and for consumers stop guessing if your skincare works or your flare ups gonna suddenly have symptoms on your skin. And for our channels include direct B2B and consumer direct to consumer e-commerce and hospital distributors and the clinical referrals. And our revenue streams comes from four sources: hardware sales and the patch subscriptions, SaaS, cloud-based service fees for clinics, and the license fees for pharma trials. So the hardware pricing, we sell from Aspa, we sell at $80 to $120 per unit. Our hardware cost $20 to $30. Patches cost $2 to $3. So that gives us around 70% to 80% gross margin on the hardware and 80% to 88% on the patches. For the market opportunities, the electronic skin market will grow from 13 billion to 37 billion by 2030. Home remote monitoring is the fastest growing segment. Wearable transepidermal water loss sensor are only 5% of the market today, but growing at 22% annually. This is an first mover opportunity, which is a really large and healthy margin and a clear opportunity. And we have we have to due to the fact we have to move through like three key pivots direct from our interviews. And the first we shift from direct to consumer to B2B med spa strategy. Why? Because the clinicians are trust anchors. Patients trust their clinicians more than their device, and this came from interview with our dermatologist. And second, we prioritize post-aesthetic recovery over eczema patients. Why? Because the willingness to pay is higher and the path to market is shorter. This comes from interview with the sensitive skin consumers. And the third, we deprioritize pharma trials as needed entry points due to the long sales cycle and FDA requirements, while keeping them as a long-term opportunity. This came from interview from the patient outcome study experts. And our customer journeys have 5 stages. Stage 1 is the awareness. Customer learn about flat sensors through clinical referral. Interview interview shows that a doctor recommendation matters more than any like advertisement. Stage 2 is consideration. Today people rely on trials and errors. So our advantage is continuous battery-free monitoring with visual feedback. And stage 3 is purchase. For med spas, this is a B2B decision. Young patients won't wear a visible device, so it decreased design is the key. Stage 4 is usage. Customer wear a patch and gets trend alert. Interview wanted to have a quick feedback, and this can protect their skin, as they said. And stage 5 is advocacy. So when consumers are happy with the product, they will like to refer to others. And the issue is consumer today don't know what transepidermal loss technology is, so we need to educate this. And also down below is the 5-year roadmap. And from 2026, we launch B2B2C through med spa, target 20 spas and 100 units. And in 2027, we expand from direct to consumer for eczema and VOC detection, scale around 500 units. In 2028, we obtain 510K FDA clearance, and we launch pharma trials. In 2029, for the scale, we enter hospital and for wound monitoring. And for 2030, we become the standard of care. Hopefully, pursue our reimbursement and existing strategy for. So in the end, we need to go Mexico first, direct to consumer second, and then at the same time we build through FDA clearance. To move forward, and we have our we need to understand our potential audience, what they are looking for, and what we can provide, and their 5 immediate actions. And first, we need to sign MASPA agreements in the 6 months to validate B2B2C business models. And second, we prepare a research IRB submission for a wound healing study on diabetic ulcer and the burns with different future more like serious trials preparations. And this will address like something such as like life-threatening conditions identified with like intervals before. And the third, we began our pre-communication with FDA regulatory consultant, and within like two months to clarify what's the pathway for our goal, and to get feedback from more interviews, and then focus on the clinical endpoint validation. And for step 4, we establish experts advisory report, including like skin barrier experts and wound healing experts in the 3 to 6 months. And then 5th, we keep looking for potential user for interview, and also collecting ongoing process for all the possible data and users. And we also need to target future more like customer interview categories, such as eczema, atopic, and so for clinical researchers to validate transepidermal water loss predicts skin flare-up issues, and it will help to support the R bigger than 0.7, which is FDA medical health standard. And this will also support by our first patient outcome experts who we have FDA standard evaluations. And then we also need to collect the clinical trial investigators with digital endpoints experience to understand FDA evidence requirements for early warning claims. And this follows from interviews of focus on the FDA acceptance. And for category 3, we can starting to collect the ICU nurse and burn units physicians to understand the workflow for critical skin month. And this follows from dermatologist insights that is the greatest in this life-threatening conditions where the missing change can be like fatal. So in conclusion, this is all the information I have gathered, and hope this is something useful. Thank you.
All right. Working alone, you did all 22 interviews yourself?
Yes.
Wow.
Actually, the doctor student, she helped me collect some professional.
That's great.
Yeah.
Okay, excellent.
Yeah.
Any questions? Very thorough job.
Yeah.
And thank you for keeping it brief. I think we're done here at 9 o'clock on the dot. Next week, we will have 5 teams presenting. There is no guest speaker, from what I remember. And hopefully we'll be done a little bit early. Try to keep your presentations to 20 minutes or less. I think that would be consistent with what we saw tonight. So again, nice job. Well done. See you all next week. What's that? I can't hear what you're saying.
Oh, internet attendance.
There isn't this week. Sorry, Cy was out this week, so I don't have an attendance book. It'll be honor systems. Because we all smiled. Sure. Honor system. Okay.
You guys.
Oh, digital exam, LLM,
They're all like in class, right?
they're in class, they monitor, it's closed book, and allow them one cheat sheets of both sides.
Yeah.
It's just like 1990 all over again.
Yeah.
Students, for 10 minutes, they complained that they couldn't actually write physically.
Yeah, really. I was gonna say that people don't know.
Yeah, this was for learning, but like, people make the exam longer or the questions shorter, you know.
You gotta watch for though, when we come back to Google Glass or whatnot and start incorporating LLMs into the day of our team.
Raise your glasses off.
Strip down, naked, take your exam.
This is a big topic of discussion amongst those who teach. It's just like, how do we teach exams, especially since everything used to be digital and online? It's like, we can't do that anymore.
Everything has to be oral.
Oral exam. Weren't, that qualifying exams, I mean, final dissertation, those are all.
At some point, we need to get some feedback on how to give a presentation. I think this mode of,
Reading.
every single, and in some cases, you get the sense that it's the first time they've ever read it. They're not the person to pronounce some of the words.
Yeah, I agree. Yes.
Yeah.
But and also, it's a literal thing of reading every word and
then the work on what's being said and what's on the slides. It's like foods and so you look at the slide and trying to figure out what you
right.
Which part of the slide.
Well, I chose not to do the style discussions in class. I think it's because the plan is organized.
Yeah, no, it is, but it's
for the
full feedback.
Yeah.
Right, they should hear that.
Well, I can certainly incorporate that. I gave them feedback on the midpoint presentations on slide by slide, basically. I'll have the videos. I can get people to view the video feedback on that.
Thanks, Bruce.
Thank you.
Thanks, guys. Yeah, have a good one. See you guys.
All right.
Bye, Mark.
Take care. See you.
See ya. Bye.